All right, good morning, everybody. All right, we are back on the state of Georgia versus Travis McMichael, Gregory McMichael, and William R. Bryan. With the jury having reached a verdict, the court indicated that it would schedule sentencing. The sentencing was noticed for today. Is the state ready to proceed?
Yes, Your Honor, the state is ready to proceed.
Is Travis McMichael ready to proceed?
Yes, Your Honor, we're ready.
Greg McMichael.
Yes, Your Honor.
And Mr. Bryan.
Yes, Your Honor.
Okay. Any preliminary matters from the state?
No preliminary matters from the state, Your Honor.
Any preliminary matters from Travis McMichael?
No, Your Honor.
Greg McMichael?
No, Your Honor.
And Mr. Bryan?
Yes, Your Honor. We filed 3 motions this morning. I have a 4th motion to make orally. I'm not going to belabor them at any great length, but I did want to have them on file for the record. We filed this morning a motion to bar imposition of sentence of life without parole as to defendant Bryan for felony murder. That is basically, we're arguing for an extension of the decision of the U.S. Supreme Court in Edmond v. Florida, which held that individuals who are convicted of felony murder without killing, attempting to kill, or intending to kill are not eligible for the death penalty. We're pursuing that both under the 8th Amendment to the United States Constitution and Article 1, Section 1, Paragraph 17 of the Constitution of the State of Georgia. We're asking the court to extend that reasoning one step further, reflecting evolving standards of decency, and hold that the imposition of a sentence of life without parole for felony murder would likewise be unconstitutionally cruel under our constitutions, absent evidence that defendant Bryan killed, attempted to kill, or intended to kill Ahmaud Arbery. We don't believe any of those facts are in dispute in this case. That's our first motion.
Anything from the state?
Yes, Your Honor. The reason felony murder and different from malice murder is because of the lack of specific intent to commit the murder. As we all know, when a co-defendant like 2 men go into a convenience store and they attack the convenience store clerk, and the clerk, defending himself, shoots and kills one of the armed robbers. The first armed robber is responsible for the death of his friend and co-defendant under felony murder, because while there was no intent for one armed robber to kill the other armed robber, it's a matter of responsibility under felony murder, not a matter of intent to kill. And in this particular case, Mr. Bryan is eligible for this court to impose a sentence of life without the possibility of parole. There is nothing preventing this court from doing that on a felony murder charge, because felony murder, once again, is about responsibility, not about intent to kill. Thank you.
All right. Mr. Goff.
Your Honor, with all due respect, and it's not a casket, I don't believe that response addressed the issue. The issue is for an individual system such as Mr. Bryan, who did not kill, did not attempt to kill, and did not intend to kill, whether or not the 8th Amendment allows the imposition of a sentence of life without parole is not a question of the Georgia sentencing scheme or statutes. It's a question of federal constitutional law. Clearly, under those circumstances, the death penalty, imposition of the death penalty, is cruel and unusual. We are contending since Edmond v. Florida in 1982 that standards and our sense of decency in society have evolved to the point where the 8th Amendment does not allow the imposition of a sentence of life without parole for felony murder, absent killing, an attempt to kill, or intent to kill. And I don't think the state contests that those are not the facts of this case. I think the state is relying on the fact that the United States Supreme Court hasn't addressed this issue yet, at least not to my knowledge. We're preserving the issue for appeal.
All right, the court received the motion to bar imposition of sentence of life without the possibility of parole as defendant Bryan for felony murder this morning. It looks like it was filed at 8:18. I have reviewed the motion. It cites the one case that was just referenced by Mr. Goff. And having considered the arguments of counsel, the court denies the motion. Mr. Goff.
Thank you, Your Honor. Our second motion is a motion to declare unconstitutional mandatory life sentence for felony murder for a discrete class of offenders, and in the alternative, motion to bar imposition of life sentence as to defendant Bryan for felony murder. The previous motion addressed whether or not Mr. Bryan was eligible under the Eighth Amendment for a sentence of life without parole. This motion challenges whether Mr. Bryan can be sentenced to a mandatory life sentence for felony murder, both as a class of individuals who have not killed, intended to kill, or attempted to kill, and also as to Mr. Bryan individually. And we contend that this is essentially, the first part of it is taking the Enman case that has already been discussed this morning, not one step, but two steps, to strike down mandatory felony murder for people that convicted of felony murder that fall within that class of individuals that have not killed, attempted to kill, or intended to kill. This is an issue which has tremendous import in the state of Georgia and around the country, in that there are hundreds in Georgia and probably thousands of individuals around the country who are serving life sentences, have been in prison for many, many years, who drove the car that was used to escape from the armed robbery, or provided the key to break into the house not knowing that it was occupied. There's all kinds of people out there across the country serving life sentences right now who never killed, attempted to kill, or intended to kill, but have been subjected to mandatory life imprisonment. I would venture to say the majority of those individuals tend to be African American, but I haven't studied it in depth in a while. But that doesn't matter. It doesn't matter whether you're white, black, or Martian. It's still wrong for the legislature to require this court, to compel this court as a matter of law to impose a mandatory life sentence on an individual who hasn't killed, attempted to kill, or intended to kill. And again, this is an issue that would have significant impact if it were granted, but we are certainly preserving that issue. Secondly, with respect to Mr. Bryan individually, we believe that he is not eligible for imposition of a mandatory life sentence pursuant to the Eighth Amendment, based on the totality of the circumstances surrounding the offense, his criminal history and other circumstances, which we'll get into during the sentencing hearing, and that the imposition of a life sentence to Mr. Bryan would be unconstitutionally cruel and disproportionate. And we cite the relevant Supreme Court authorities as to that issue.
Thank you, Judge. Your Honor, the legislature has spoken not only with 1651, which imposes a mandatory life sentence for felony murder, but also with party to a crime and conspiracy. All of those laws are on the books for a very important reason, which is responsibility for your actions. And at this point, the state is asking that this court not fly in the face of the legislature or the statutes that are on the books, especially 1651, based on this particular argument that somehow Mr. Bryan is special and outside the imposition of the law. Thank you.
Any further word on that motion?
On behalf of Greg McMichael, we'd like to join that motion, but without any further argument.
It doesn't apply to us, really.
Your Honor, I don't have to object. I'm arguing, I guess. But the idea that Mr. Bryan is asking for special treatment here is just wrong and contrary to the argument actually made. Our position is that no one in America convicted of felony murder who didn't kill or attempt to kill or intend to kill should be subjected to a mandatory life sentence. That doesn't mean that a court couldn't impose a mandatory life sentence. It means that the court should constitutionally have the discretion to impose the sentence that is appropriate, and for the legislature to dictate that these individuals, such as Mr. Bryan, the court cannot consider a sentence of less than life imprisonment is cruel and unusual, and this practice needs to stop. It's gone on since before I was born, before Your Honor was born. It was wrong then, it's wrong now, and sometime, somewhere, it has to stop. Secondly, as to Mr. Bryan individually, Again, it's not suggesting that Mr. Bryan is special. It's suggesting that anyone in Mr. Bryan's circumstances, under the facts of this case, anyone besides Mr. Bryan, with the same criminal history, with the same background, with the same circumstances, that imposition of a mandatory life sentence would likewise be disproportionate as to them. So this is not a request for special treatment. It is a request for individualized sentencing consistent with the Eighth Amendment.
All right. Again, the motion is filed this morning. I did have an opportunity to review the motion. Having heard the arguments of counsel, the court denies the motion. Mr. Goff.
Our third and last formal written motion is a motion to vacate the illegal felony murder convictions based on double jeopardy. And I don't want to be accused of plagiarizing. An inmate apparently from the Michigan criminal prison system, Mr. Sires, was kind enough to draft a motion for me to file, and even went out and found Georgia case law. Your Honor, I have to confess it doesn't quite reconcile with my memory of all of the Georgia case law, but the argument's pretty good. Mr. Bryan was acquitted of count 2, felony murder. There is only one felony murder statute. And therefore, once you've been acquitted of felony murder in count 2, double jeopardy bars conviction under counts 3, 4, and 5. The argument being that they're all different ways to commit the same offense. And we believe that under the authorities, which are not just state authorities, they're federal authorities, including Sanabria v. U.S., 437 U.S. 54, that the court should find that double jeopardy bars imposition of sentence under counts 3, 4, and 5. Independent of that, we also have an issue with respect to the jury returned a verdict of not guilty as to the lesser offenses on count 7, and therefore the verdict on count 7 is repugnant with the verdict of the jury as to the lesser offenses. I would note, I don't recall the court asking the jury to address the lesser offenses unless and until Mr. Bryan was found not guilty on the indicted offense of count 7. But nevertheless, the jury did return verdicts of not guilty. The state did not object to the return of those verdicts at the time. And those not guilty verdicts on those 3 lesser offenses are repugnant to the conviction on count 7, and therefore count 7 should be set aside for that reason. And that is my motion.
From the state.
Thank you, Judge. Your Honor, it has been the law in the state of Georgia and commented and gone over by the Supreme Court of Georgia, especially as recently as 2015 in Duggar versus the state, D-U-G-G-E-R versus the state, 297 Georgia 120. And similar circumstances where a defendant was found not guilty of the malice murder charge, but guilty of the felony murder charge, and he claimed double jeopardy because only one person was dead and they came back not guilty on the malice. And in this particular case, Duggar, they said, no, that's not how this works. Appellant faced a single prosecution and he received a single punishment for murdering the victim. That's the quote from this. His double jeopardy rights were therefore not violated. In addition, he wanted to argue that these were inconsistent verdicts. Once again, the court held that that is not the case. There was no inconsistency between the verdicts of guilty on felony murder and not guilty on malice murder. Now, of course, in this case for Mr. Bryan, he's claiming, well, there was a series of felony murders. Well, the felony murders are predicated on certain underlying acts. And in this case, the jury did find him not guilty of aggravated assault with a shotgun and also not guilty of felony murder based on that aggravated assault with the shotgun. So therefore, their verdict was consistent in that manner, but they did find him guilty of aggravated assault with the pickup truck, false imprisonment, and criminal attempt at false imprisonment, and the felony murder associated with that. The state is going to, of course, argue that 2 of those felony murders will be vacated by operation of law and that Mr. Bryan will only be sentenced to 1 of the felony murder counts. And so therefore, based on Duggar as well as numerous other cases, and I believe Duggar was most recently cited in 2020 by the Strong case by the Georgia Supreme Court, that there is no legal sound legal basis in the state of Georgia for a double jeopardy claim, as well as numeration 22 on page 4 of defendant Bryan's motion, finding someone not guilty of a lesser charge doesn't necessarily mean they're not guilty of a more egregious charge. So the fact that they came back not guilty on those lesser charges versus the more heavy charge does not all of a sudden mean that it's a repugnant and or inconsistent verdict. We ask that you deny the motion. Thank you.
Your Honor, as Ms. Donikoski was so kind to point out, Duggar is readily distinguished. Obviously, malice murder is one crime, felony murder is another. Ms. Donikoski is confusing the merger concept with the double jeopardy issue. In this case, these are all felony murder counts, but they're all the same crime. So that is what distinguishes the Duggar case. And furthermore, with respect to the lesser offenses, Your Honor, the jury's verdict on the 3 lesser offenses of not guilty indicates that the jury concluded that an element of the offense, the greater offense, was missing. The verdicts are repugnant. I would submit they're repugnant as a matter of law, and that therefore the court must vacate count 7 as to Mr. Bryan. And that doesn't mean that there won't be 2 other felony murder counts left. It may be an academic discussion, but nevertheless, we're asking the court to vacate the conviction under count 7 as repugnant with the 3 misdemeanor counts and impose sentence on the misdemeanor count only.
Again, as previously indicated, the court received the motion this morning. I did take a look through the motion. We've taken a look at Duggar, cases cited by the state, and the court denies the motion. I understand you've got one oral motion?
Yes, Your Honor. And I appreciate the court's patience. Your Honor, we are making an additional constitutional challenges to Georgia's sentencing scheme with respect to the imposition of a sentence of life without the possibility of parole. And again, as I think prosecutors suggested many years ago, a lot of the sentencing jurisprudence and criminal law jurisprudence began in death penalty cases with the theory that death is different. Well, I think the evolving case law over the last several decades has demonstrated that death is really not so very different after all. We assert 8th and 5th Amendment challenges to Georgia's sentencing scheme, which rightly gives judges broad discretion in determining sentences, but with respect to life without parole, that discretion is effectively unguided, as opposed to the sentencing scheme in a death penalty case for determining the imposition of the death penalty. Besides being cruel, the sentencing scheme also violates due process in that the statutes fail to provide sufficient guidance to the trial court. And therefore, Georgia's sentencing scheme is hopelessly ambiguous as well as arbitrary and capricious. Moreover, without any required findings of fact or conclusions of law, there is nothing for an appellate court to review to determine whether a sentence of life without parole has been lawfully imposed. Furthermore, we assert a 6th Amendment challenge, which I would call an Apprendi challenge, although it's not actually the authority, that any facts that increase a mandatory minimum sentence must be set, which in this case would be life without parole as opposed to a life sentence, that any fact that increases a mandatory minimum sentence must be submitted to a jury and found true beyond a reasonable doubt. And I cite Olen v. U.S., A-L-L-E-Y-N-E, 133 S. Court 2151, 2013. Blakely v. Washington, B-L-A-K-E-L-Y v. Washington, 542 U.S. 296, 2004. Your Honor, the jury acquitted as to counts 2 and 6. With count 7, it is impossible to determine what facts the jury found in this case because the state elected to pack so much into count 7. You've got parties to the crime, you've got principals to the crime, you've got the McMichaels pickup truck, you've got Mr. Bryan's pickup truck, and you've got whether it's an intent to injure, or whether it's placing Mr. Arbery in reasonable apprehension of receiving an injury. There's so many different theories that the jury could have returned a verdict on that there's no way to draw any findings, meaningful findings of fact for sentencing purposes from the verdict that the jury rendered. And therefore, under these circumstances, there's nothing here for which the court could find a jury-found basis for imposing the sentence that the state is seeking in this case. Thank you.
Judge, on behalf of Mr. McMichael, we would join the motion.
On behalf of Greg McMichael, we'd like to join that motion.
Noted for the record. From the state.
Of course, the state's at a bit of a disadvantage, just having heard the motion, as is the court. However, the state's position at this point in time is this is a legislature issue. The legislature has passed 1651, and it is a mandatory life sentence. The court does have discretion between life or life without the possibility of parole. The complaint here, it sounds like, is, well, there's an Eighth Amendment violation, a Fifth Amendment violation, a Sixth Amendment violation because there's no guidance to the court. However, as this court is aware, the Supreme Court of Georgia has given Superior Court judges great deference because this court has heard the evidence. This court has seen the demeanor of the defendants, especially in this particular case, the demeanor of Travis McMichael as he testified. This court has seen the evidence from the witnesses on the stand and the body cam video of what took place. So in this case, the court is going to be given and has received the evidence in this case for its review to inform it and its discretion as to whether to impose a life sentence or a life sentence without the possibility of parole. I believe the next step in this process, of course, is going to be the state presenting victim impact and then argument. The defense will present its argument, all of which also informs this court and allows it to use its broad discretion and judgment as to whether to impose a life sentence or a life sentence without the possibility of parole. So we ask that you deny this motion. Thank you, Judge.
Final word.
Your Honor, with all due respect to Mr. Dunkowski, this is not a legislative issue. The Constitution is not up for discussion or negotiation. The Constitution is what it is. The Fifth, Sixth, and Eighth Amendments to the United States Constitution are the federal provisions at play here, in addition to the parallel provisions of our Georgia state Constitution. Legislators are politicians. They have to run for election, and they do what they think they need to do. And the job of the judiciary as the independent third branch of government is to put a check on that action when it violates our state and federal constitutions. So simply saying that it is a legislative issue, it doesn't address the question. And ultimately, it is for our courts to defend that Your Honor and the courts above you are the ultimate guardians of our state and federal constitutions and of the individual rights of individuals. And to simply say, or maybe that wasn't the suggestion, but one could interpret it that way, that the courts should simply defer to the legislature as to what the Constitution means, to the extent that was their argument, is repugnant to our entire system of criminal justice. I'd ask the court to grant the motion.
All right. I didn't hear the argument quite that way, where the court has to defer to the legislature. There is a structure in place with regard to sentencing, and this court intends to adhere to that structure as established through Georgia case law. On that basis, the motion is denied. All right, I understand those are all preliminary matters. Then before the court, is the state ready to proceed with, and the way we're going to do it, as I understand it, is the state is going to present any evidence it has in aggravation as well as a opening argument. The defense is then going to have an opportunity each individually to present any evidence in mitigation if they wish to do so, and make argument, with the state then having the rebuttal. That's how I understand we're going to proceed. From the state.
Thank you, Judge. Your Honor, for the record, today is Friday, January 7th, 2022. The jury returned its verdict on November 24th, 2021. That verdict was that Travis McMichael was found guilty on all 9 counts in the indictment. Greg McMichael was found not guilty of count 1, which is malice murder, but guilty on the other counts 2 through 9 in the indictment. Mr. Bryan was found guilty only as to counts 3, 4, and 5, all felony murder counts, and the underlying felonies corresponding to those felony murder counts, which were counts 7, 8, and 9. The court asked all of us to look into, with regard to Travis McMichael, the issue of potential merger as to the malice murder charge. The state has reviewed its own indictment and notes that it charged Travis McMichael, who was found guilty of count 1, malice murder, a human being did unlawfully, with malice aforethought, cause the death of Ahmaud Arbery, a human being, by unlawfully chasing him through the public roadways of the Satilla Shores neighborhood in pickup trucks and shooting him with a shotgun, contrary to the laws of said state, the good order, peace, and dignity thereof. As the state notes, this encompasses 2 different actions. Unlawfully chasing him through the public roadways of Satilla Shores, which describes the actions they did in the pickup trucks, and then shooting him with the shotgun. As the court will recall, defense filed a demurrer to count 1, saying this was surplusage and should be removed. The state's argument was that the state was not going to argue it was an either-or situation, and that is not going to be the state's argument here. The state's argument here is that factually, the state believes that count 8, false imprisonment, factually has been eaten up by the way the state charged count 1 in this indictment. In other words, count 8 and count 6 would merge into count 1 for Travis McMichael on the malice murder charge because of unlawfully chasing him, meaning Mr. Arbery, through the public roadways of the Satilla Shores neighborhood in pickup trucks. The reason we believe that that factually would merge is because count 8 is actually the false imprisonment charge. And count 8 does say, said accused did chase Mr. Arbery with a Ford F1 pickup truck and a Chevy Silverado pickup truck through the public roadways of the Satilla Shores neighborhood and did confine and detain Ahmaud Arbery. As the court is aware, the statute has nothing to do with chasing. That is descriptive language factually. The statute has to do with confining and detaining the victim. The fact that the state used up factually both the chasing in count 8 and the chasing in count 1 means both count 6 and 8 would then merge into count 1. I believe, and I could be wrong, but I will address this, that the defense may argue that count 7 and count 9 would also then merge into count 1 malice murder. However, the state's argument is that is not the case. The reason for that is count 7 is the aggravated assault with the pickup trucks. Did make an assault upon the person of Ahmaud Arbery with a Ford F-150 pickup truck and a Chevy Silverado pickup truck. An object, device, or instrument, when used offensively against a person, is likely to result in serious bodily injury. That, of course, factually can be a number of different things, and what the state did argue in closing argument was pulling up next to somebody, startling them, could put them in reasonable apprehension of receiving serious bodily injury. The state also argued in its closing argument that Travis McMichael, despite his testimony, actually used his pickup truck to pull in front of Mr. Arbery and cut him off, which caused Mr. Arbery on Burford to turn around and run away. So the fact that the jury found that they used their pickup trucks, objects which used defensively against a person are likely to result in serious bodily injury, did create an aggravated assault for Mr. Arbery, does not merge into count 1, which was unlawfully chasing him through the public roadways of Satilla Shores in pickup trucks. They are 2 separate and distinct things, especially when we have video evidence of the McMichaels pulling up next to Mr. Arbery then running away. That itself right there is an aggravated assault. He was obviously startled. He obviously was trying to get away from these men. They pulled up next to him. Reasonable apprehension of receiving serious bodily injury. With regard then to count 9 is criminal attempt to commit the felony of false imprisonment. As the court will recall, the defense also demurred to that particular charge in the indictment. That particular charge in the indictment did have an "and" in it, which, as the court knows, is an "or," which the state explained in its closing argument to the jury. In this particular count, count 9, it did charge the defendants with unlawfully chasing, or did unlawfully chase Ahmaud Arbery through the public roadways of the Satilla Shores neighborhood in pickup trucks, and did attempt to confine and detain Ahmaud Arbery without legal authority on Burford Drive using a Ford F-150 pickup truck. In this particular instance, the state did argue and did inform the court in the demurrer response that it was going to argue and/or, because as we know, a criminal attempt is just a substantial step toward committing that particular felony. And as the court will note, count 8 took place on Holmes Drive, whereas count 9 was on Burford. So they don't have anything to do with each other. They're two separate incidents at two separate points in time based on the evidence in this case. So either one could be considered a substantial step, and because the "and" in between unlawfully chase and did attempt to confine and detain is really an "or" for the purposes of this, and once again, the state put that in its response to demurrer by the defendants, and the court denied the demurrer. That was filed by the defendants. The state also argued in closing argument that that was an "or." They could find it that he was chased. They could also find that on Burford they did attempt to confine and detain him, especially with Mr. Bryan's actions of trying to run him off the roadway from his driveway, and with Mr. McMichaels' actions of cutting him off at the end of Burford. So in this particular instance, especially with the criminal attempt, it does not merge into malice murder simply because of the words "did unlawfully chase him through the public roadways" contained in count 1. Therefore, when it comes to Mr. Travis McMichael, the state's position on sentencing and merger is this: that he is looking at a life sentence on count 1, malice murder, that counts 2, 3, 4, and 5, all felony murder, would be vacated by operation of law. Count 6, which is the aggravated assault with the shotgun charge, would factually merge into count 1. Count 7 would remain standing, and count 7 is a potential sentence of 1 to 20 years on the aggravated assault with the pickup trucks. Count 8, in the state's opinion, would factually merge then into count 1. False imprisonment, of course, is a 1 to 10 potential sentence. And count 9, criminal attempt, cuts that sentence in half. So count 9, criminal attempt to commit false imprisonment, is a potential of 1 to 5 years. Therefore, the minimum sentence that this court could impose on Travis McMichael would be life with the possibility of parole with 15 years, and that court could suspend, probate, run concurrent with that particular sentence. The maximum, and that is what the state is asking for in this case, is a life without the possibility of parole. The state did file its notice of its intent to seek life without the possibility of parole back in 2020 when this case was first indicted. So the state is seeking life without the possibility of parole as to count 1. Counts 2 through 5 are vacated by operation of law. Count 6 would merge into count 1, leaving then count 7 and 9, which would be 25 years. We are asking that that 25 years be a 25-year sentence, but to be run concurrent if the court chose to impose a life without the possibility of parole sentence. And that would be count 7 concurrent with count 1, 20 years to serve. Count 9 concurrent with count 1, consecutive to count 7, thus making it a total of 25 years running concurrent with the life without the possibility of parole sentence on count 1 for Travis McMichael. And that is what the state will be requesting and seeking. With regard to Greg McMichael, he was found not guilty on count 1, malice murder. He was then found guilty of counts 2, 3, 4, and 5, all felony murder. The state is seeking, therefore, a life without the possibility of parole sentence on count 2, which is felony murder based on count 6, which is the aggravated assault with the shotgun. Counts 3, 4, and 5 would be vacated by operation of law. Count 6 would merge into count 2. the felony murder. In this particular case, that felony murder only alleges did cause the death of Ahmaud Arbery based on the aggravated assault with a shotgun, so we do not have the same issue with language of chasing in count 2 of this indictment. This would, of course, leave count 7, count 8, and count 9 available for sentencing. Count 7 is aggravated assault with the pickup trucks. That's a potential 1 to 20-year sentence. Count 8, false imprisonment on Holmes Drive, a 1 to 10-year sentence. Count 9, criminal attempt to commit false imprisonment, a 1 to 5-year sentence. So the minimum Greg McMichael is looking at is life with the possibility of parole and 35 years. That 35 years can be run concurrent, it can be probated, it can be suspended. The maximum Mr. McMichael is looking at, Mr. Greg McMichael is looking at, is count 2. The state is going to be asking for life without the possibility of parole. Counts 3, 4, and 5 are vacated by operation of law. Count 6 would merge into that life without the possibility of parole sentence, and the additional 35 years to be run concurrent consecutive, meaning count 7 concurrent with count 2, 20 years to serve. Count 8 concurrent to count 2, consecutive to count 7, and count 9, the 5 years to serve, concurrent with count 2, consecutive to count 8, resulting in a 35-year sentence to be run concurrently with the life without the possibility of parole sentence on count 2. With regard to Mr. Bryan, Mr. Bryan was found not guilty of counts 1 and 2. He was, however, found guilty of the 3 felony murder counts, count 3, 4, and 5, based on aggravated assault with a pickup truck, false imprisonment, and criminal attempt at false imprisonment. The state is looking at a life sentence on count 3. Counts 4 and 5 would be vacated by operation of law. He was found not guilty on count 6. Therefore, count 7, the aggravated assault with the pickup truck, would merge into count 3, because count 3 is the felony murder based upon count 7. So count 7 would merge into count 3. Count 8, false imprisonment, potential 1 to 10-year sentence, and count 9, a potential 1 to 5-year sentence. Therefore, the minimum Mr. Bryan is looking at is a life with the possibility of parole sentence, plus an additional 15 years, which once again can be run concurrent, it could be run consecutive, it could be probated and or suspended. In this particular case, the state is going to make a recommendation for Mr. Bryan of life with the possibility of parole on count 3, with 15 years to serve consecutively on probation. And that is going to be our recommendation for Mr. Bryan. Your Honor, at this time, the state will go ahead and present its victim impact evidence for the court's consideration, and then once that's through, we will make our argument. Thank you. At this time, we're going to present Mr. Marcus Arbery.
I do want to make a point before we get into the victim impact statements, and not to imply that this would go any other way, but I do want to make sure that those that are addressing the court address the court as opposed to anybody else in the gallery. So let's go ahead and proceed. Good morning.
Good morning. How y'all doing? Right. It's a hard time with me and my family. You know something that I just doesn't sit right with me at this time. The man who killed my son has sat in this courtroom every single day next to his father. I'll never get that chance to sit next to my son ever again. Not at a dinner table, not at a holiday. And not at a wedding. He'll never get to have I pray that no one in this courtroom ever has to do what we had did, that buried their child. There's no word for that because no word knows that much pain. Not only did they lynch my son in broad daylight, but they killed him while he was doing what he loved than anything, running. That's when he felt most alive, most free. And they took all that from him. When I close my eyes, I see his execution in my mind over and over. I'll see that for the rest of my life. When I became a father, my life became bigger than me. It became about my family, about protecting him, protecting my boy. I know in my head that there's nothing I could have done that day to have saved my son, to have protected him from that evil and hate. But my heart is broken and always will be broken because on my worst day or our lives wasn't there. If I could, I'd have traded places with Amar in a heartbeat, but I can't. So I'm standing here today to do what he can't, and that is to fight for him, fight for his memories, his legacy, and to tell you who he was, because that's the one thing you didn't hear in this courtroom. And more than anything else, you should know who my boy was. We love our son and we will never have him with us to celebrate anything. Thanksgiving, Christmas, or his birthday. His kids should spend the rest of their lives thinking about what they did and what they took from us. And they should do it from behind bars. Because me and my family, we got to live with his death the rest of our life. We'll never see him martyred again. So I feel they should stay behind them bars the rest of their life because they didn't give him a chance. Thank the court. Thank y'all for what y'all did with our family stuck by us. Thank the jury. I give all glory to God. Thank y'all.
Thank you, Mr. Aubrey.
Ms. Jasmine Arbery.
Good morning. My name is Jasmine Arbery. Ahmad is my brother, and I would like to tell you a little about him. Ahmad had dark skin that glistened in the sunlight like gold. He had thick, curly hair, and he would often like to twist it. Ahmad had a broad nose, and the color of his eyes was filled with melanin. He was tall with an athletic build. He enjoyed running and had an appreciation for being outdoors. These are the qualities that made these men assume that Ahmad was a dangerous criminal and chase him with guns drawn. To me, Those qualities reflected a young man full of life and energy, who looked like me and the people I love. Ahmad was funny. He told jokes to lighten the mood because he was a positive thinker. Ahmad had a big personality and never missed the opportunity to let it shine. Ahmad had a future that was taken from him in an instance of violence. He was robbed of his life pleasures, big and small. He would never be able to fulfill his professional dreams, nor would he be able to start a family or even be a part of my daughter's life. The loss of Ahmad has devastated me and my family. So I'm asking that the man that killed him be given the maximum sentence available to the court. Thank you.
Thank you, ma'am.
Ms. Wanda Cooper-Jones.
Good morning.
Good morning, Your Honor. I want to first speak directly to my son, if I please. This verdict doesn't bring you back, but it does help bring closure to this very difficult chapter of my life. I made a promise to you. Today, I laid you to rest. I told you I love you, and someday, somehow, I would get you justice. Son, I love you as much today as I did today that you were born. Raising you was the honor of my life, and I'm very proud of you. Your Honor, these men have chose to lie and attack my son and his surviving family. They each have no remorse and do not deserve any leniency. This wasn't a case of mistaken identity or mistaken fact. They chose to target my son because they didn't want him in their community. They chose to treat him differently than other people who frequently visited their community. And when they couldn't sufficiently scare him or intimidate him, they killed him. My youngest son, he was born on Mother's Day of 1994. He had a smile so bright it lit up a room. He was a greedy baby that seemed like he was always searching for something to stick into his mouth. He was always a loving baby who seemed to never tire of hugs, cuddling, and kisses. He loved, he never hesitated to tell me, his sister Jasmine, and his brother Marcus that he loved us. And Your Honor, we loved him back. He was messy. He sometimes refused to wear socks or take good care of his good clothing. I wish he would have cut and cleaned his toenails before he went out for that jog that day. I guess he would have if he knew he would be murdered. My family is gonna miss Ahmad. We're going to miss his jokes, his impersonations, his warm smile. These men deserve the maximum sentence for their crimes. Ahmaud never said a word to them. He never threatened them. He just wanted to be left alone. They were fully committed to their crimes. Let them be fully committed for the consequences. Your Honor, I'm standing here for you as the mother of Ahmaud Arbery, asking you to please give all 3 defendants who are responsible for the death of my son the maximum punishment in this court, which I do believe is life behind bars without the possible chance for parole. Thank you.
Thank you, ma'am. Any additional evidence and aggravation from the state?
No more additional evidence from the state, Your Honor.
Argument?
Your Honor, the state is seeking life without the possibility of parole for the McMichaels, based primarily on the evidence presented in this case. The state is not going to go through all of that evidence, just a few very important items. First off, there was a demonstrated pattern of vigilantism by Greg and Travis McMichael. First off, we have our July 13th, 2019 911 call after both of them went with guns to confront a homeless man who was living under the bridge, who they suspected must have been committing all of these crimes. Of course, all of these crimes included a lot of reports to 911 about suspicious persons, and as we heard from the witness stand and defense witnesses, a couple of unlocked cars with things stolen out of them by people outside the neighborhood. And then we have February 11th, 2020. Yes, Ahmaud went inside of the open, unsecured construction site that particular day. But Travis McMichael went home, got his father, they both got their guns, and then they went back down to that construction site. We know that because we heard the 911 call. And he says, I'm sitting outside the construction site. He talks about seeing somebody inside with a flashlight. The horrible part is we know from Brooke Perez, who testified for the defendants, that her husband had gotten a call from Larry English, and he'd gone over there with his handgun. We also know that the 2 men went inside with their handguns. It's a miracle they didn't shoot each other. And no one had called the police. Travis is outside in the pickup truck, finally calling the police. He stays on for about 4 minutes, and then Officer Ash appears. That didn't teach anybody here a lesson at all. Brooke Perez was trying to tell them, no, my husband's over there with a gun. Be careful, go in there. But Greg McMichael took off, according to Travis's statement, down the street and went right into that house. So we've got July 2019, February 11th, 2020. Not calling 911 first, not staying home, but wanting to seek out, in a vigilante manner, a confrontation with people that they suspect might be doing something that they themselves, up until January 1st of 2020, had not been the victim of. In all cases, they took firearms with them, did not stay home, did not allow the police to do their job, but instead, as on February 11th, Greg McMichael went in and started searching the house himself. We all know how that could have turned out terribly for him, for anyone in there, and for Diego Perez. All the decisions they made that led up to the death of Ahmaud Arbery. There were so many opportunities to stop, to think. And here's the real problem. Greg McMichael was former law enforcement, as they pointed out repeatedly. And Travis McMichael had served in the Marines. I'm not the Marines, the Coast Guard, as they pointed out repeatedly. So here we have some men who should have known better. Should have known better. Vigilantism always goes wrong. You wait for the professionals to show up. The professionals who are in marked cars, the professionals who are in uniforms, the professionals who are going to do it right because they have something to lose, the professionals with body cams, the professionals such as Officer Rash, who just would have stopped Mr. Arbery and said, hey, I'm going to put you on the phone with Larry English so Larry English can tell you to please not to come back. And they should have known that. They had alternatives. They had choices. But instead, Travis McMichael, who stated he was putting his son Everett down for a nap, who stated that his father had all these medical and health problems, didn't say, no, Dad, I'm putting Everett down. No, Dad, you need to stay here. He grabbed his shotgun, which he stated was propped up in a corner in that house, to go with his father. And Greg McMichael was willing to get into that pickup truck and sit in a child's seat to go chase after Mr. Arbery. Greg McMichael attempted to control the narrative from the get-go at the scene. His statements were all about how they were justified, how it was self-defense, how Mr. Arbery attacked his son. When the unknown man came up to Greg McMichael at the scene, because of course the police hadn't put Mr. McMichael anywhere, told him not to talk to anybody. He was running around the scene talking to everybody. And when talking to this unknown man who walked up to give him water, he basically said, no, this guy's an asshole. He is 20 feet from Mr. Arbery's body, referring to Mr. Arbery as an asshole. There's been no remorse shown, and certainly no empathy from either man. Because empathy would have said, hey, how must this look to this person that we're chasing? Are we terrifying this person? Are we scaring them? No empathy for the trapped and terrified Ahmaud Arbery. There was thoughtlessness as to the consequences, thoughtlessness as to the alternatives, there was vigilantism. And because of that, we are asking for Travis McMichael and Greg McMichael to be sentenced to life with the possibility of parole. Travis McMichael on count 1, malice murder, Greg McMichael on felony murder count 2, with the prior sentences or the underlying charges to run concurrent consecutive per the state's prior statement. The state is going to guess that the defense will probably say that these men served their country, they served the community. Travis in the Coast Guard, Greg McMichael at the district attorney's office, but we all know it is not the 99 things you do right, not the 99 good deeds that you do, but when you take another person's life, it can't be undone, it can't be taken back.
as to what factors to take into account when differentiating between people convicted of murder. But I know this court, Your Honor, has been on the bench long enough and has tried a number of cases, including murder cases, in which you've had to make those decisions. And you've had to differentiate between defendants and be consistent in your rulings, in your sentencing, probably the hardest thing any court has to do, which is to sentence a person to time in prison. In this case, in which the state is seeking the harshest possible sentence allowable under the law, we're asking the court to reserve the harshest possible sentence under the law for those who deserve it, for the worst of the worst. When the facts of the crime show a darkness of soul, a person so depraved and heinous as to shock the conscience by their actions, or where the offender is such a danger as evidenced by his past conduct, or by his actions post-offense, such that rehabilitation is remote or impossible, those are the offenders who deserve the harshest possible punishment under the law. Those are the offenders who people would argue deserve to spend the rest of their lives in prison. Neither of those scenarios encompasses Travis McMichael or the conduct for which he was convicted. And like Ms. Donikoski, I want to spend just a couple minutes reviewing the conduct for which he was convicted, because I agree with something she said, maybe for the first time in this trial. When Travis McMichael woke up on that Sunday morning with his son Everett in his house, his goal was not to go out and kill somebody. His goal was to play with his kid. When he sat down for lunch with Everett, possibly with Greg and his mom, Lee, and sister Lindsay, his goal was not to commit a crime that day or kill somebody that day. His goal was to have a family afternoon. And when he was putting his son down at 1 o'clock or so in the afternoon, he was doing what every single person wants to and should be doing, which is taking care of their toddler son. When he got in the truck at his father's behest to find out who that person was sprinting down the road, his goal still was not to commit a crime. His goal still was not to hurt that person, but to merely investigate, to find out what was that guy doing back at the house where Matt Albenzi was motioning. And then 4 minutes later, Mr. Arbery's dead, Mr. McMichael's covered in blood, and we have what we have here and what the jury heard. And he was convicted. The jury found that his actions constituted malice murder, felony murder, and the underlying felonies. But this is not a case in which he just targeted someone recklessly, targeted someone without knowledge, misidentified someone. He knew Ahmaud Arbery. He had encountered him previously. And he had known about the fears that the neighbors felt at Mr. Arbery's continued presence. I'm not going to retry the case. The jury found that those facts did not add up to probable cause and did not justify Mr. McMichael's actions. But he didn't just go out and shoot Mr. Arbery. He only fired the shots, the fatal shots, when Mr. Arbery came at him and grabbed the gun, as Dr. Donahue demonstrated. These were not, and as reckless as those acts may have been, as Ms. Donikoski pointed out, as thoughtless as they may have been, they are not evidence of a soul so blackened as to deserve to spend the rest of his life in prison. This was not a planned murder. This was not a murder involving torture. It was a fight over a gun that resulted in Mr. Arbery's death. And for that, the jury found Mr. McMichael guilty. The state contends that 99 good acts don't overcome one bad act. And of course, legally that's true. Mr. McMichael is now a convicted felon. But 99 good acts do weigh in this court's consideration, do factor into what choice this court is going to make when sentencing Mr. McMichael to either spend the rest of his life behind bars or give him the possibility of redemption. And those acts, those 99 good acts, the court heard about those in the bond hearing. The court heard that during his time as a lifeguard at a camp for kids who have family members with terminal illnesses, that Travis McMichael actually saved the life of a boy who was drowning in the pool. The court heard that Mr. McMichael, while serving in the Coast Guard, literally saved the lives of family members who were on a boat that was taking on water. The court heard that Mr. McMichael saved the crew of a Coast Guard vessel while serving in the Coast Guard. The court heard of the letters of commendation given to Mr. McMichael by his superiors for various acts that the superiors said show superior dedication, selfless devotion to duty and consideration of others, and adherence to our core values, honor, respect, and devotion to duty. They don't excuse anything that happened on February 23rd, but when the court is weighing in the scales of justice what people deserve to spend their lives and then die in prison versus those people who deserve to be punished but then hold out hope for redemption, those are the acts the court should consider. Mr. McMichael was a devoted father to Everett. He had Everett 50% of the time, shared custody with Everett's mom, and in fact, early on was shown to be the more reliable parent, although I know that changed over time with his mom stepping up. He was a friend to many people who are now too scared to come to court and speak on his behalf. As the court knows from the testimony it heard in trial and at the bond hearing, he was always a hard worker, always had a job, never laid around letting other people support him, always paid taxes, always supported his community in a variety of ways. The discovery that we received is replete with FBI and GBI interviews of people in his community, people who told law enforcement officials of the times Mr. McMichael helped them when they were having problems, when their boat became unmoored, or when their docks were pulled off from storms, and Mr. McMichael was out there finding those things and bringing them back to the owners, or helping other people in the community, just as he thought he was doing on February 23rd. Actions that, in hindsight, turned out to be thoughtless, as Ms. Dunikoski said, or reckless, but were not evidence of an abandoned and malignant heart. Nothing in Travis McMichael's life suggests that he's a danger to society now, or will be a danger to society 30 years from now, after he has time to think, to work, to grow. When he's in his 60s, older than me right now, do we still want a person like Travis McMichael behind bars? There's nothing in his post-offense conduct that shows that he's either mentally unstable or a sociopath. He cooperated fully with police. He told the police everything he knew to tell them because he thought he was doing the right thing, even if that thing turned out not to be right. He and Greg McMichael thought they were helping their community. They thought they were helping the police catch someone who inexplicably had been in a house, and we still don't know what he was doing in the house, on 4 or 5 different occasions. He never fled. He never tried to obstruct the investigation. When he talked to his neighbors about what happened, he always expressed remorse and disbelief. If life without parole is reserved for the worst of offenders, those who are so scary, so unpredictable, and so likely to pose a threat in the future, then it is not appropriate for someone like Travis McMichael. The only purpose of a life without parole sentence, Your Honor, is vengeance. It's retribution. And the urge to seek vengeance is strong and understandable in the family. Lord knows if I was in their position, I would be seeking the same thing. But vengeance is not the foundation of our sentencing in our criminal justice system. Redemption is. Redemption is the belief that a person can learn, can grow, and still contribute after punishment. It is pointless to continue to punish a person who has undergone changes in character that distance him from the person who committed the crime decades previously. Travis McMichael, 35 years old now, should have the opportunity to show that he's grown, to show that he's changed, and the parole board, years from now, is in the best position to determine whether he should remain behind bars or can serve a useful purpose to society. Who knows where we will be as a society in 30 years? Why make a decision today that impacts so many people long after we're gone, long after you and I are retired, hopefully, but that binds the hands of those who will have to live with this decision 3 decades hence? Why make a decision today that snuffs out all possibility of growth, of redemption in Travis McMichael? Compassion for Travis McMichael and the humility to admit that we don't know what's going to happen in the future doesn't diminish the compassion that we feel for Ahmaud Arbery's family. Their loss is real and understandable. And their desire for the maximum punishment is real and understandable. But again, that's why we have judges imposing sentence and not the families of the victim. Because there are a lot of factors this court takes into consideration: deterrence, rehabilitation, retribution. Those are all valid factors. But the only thing an LWOP sentence serves is retribution. Wouldn't it be healing for Mr. Arbery's family for Travis McMichael to atone, to be able to express the remorse that's in his heart without the specter of a federal trial hanging over his head? We've heard several times today that he's shown no remorse, but this court knows that no lawyer would allow Mr. McMichael to say anything about his feelings towards the family while there were 2 pending murder trials against him. When the witnesses were interviewed by law enforcement about Mr. McMichael's conversations with them, to a person they said that he showed remorse, that he never wanted to kill somebody. He was merely trying to detain Mr. Arbery for the police. It is disingenuous and unfair to expect Mr. McMichael to express remorse with yet another trial beginning in 3 weeks, where everything he says can be used by the federal government against him. Wouldn't it be powerful, though, for Travis McMichael to look deep into himself and explore with the public, with his son Everett, why he did what he did, and in fact become a force for good while in prison and out, instead of one more old man behind bars costing taxpayers $50,000 a year or more in 30 years? Wouldn't it be healing to society for someone like Travis McMichael to be free to help heal the wounds that are certainly present in this country due to decades and decades and decades of discrimination, of racism? Wounds that we're just now beginning to try to heal. Judge, you can send a message that 4 minutes of conduct does not erase a life well lived. and that after punishment, there is opportunity for redemption. An opportunity that Travis can either take advantage of and prove himself worthy or not, and that the parole board can then determine whether he should be released from prison. We are not asking you to do anything, Your Honor, but to agree that we don't know today what the future holds. We're asking you to sentence him to life with the possibility of parole if it's earned. Judge, as far as sentencing, I would disagree with the state. I believe count 7 and count 9 do merge. I believe the language of chasing Mr. Arbery through the Satilla Shores neighborhood that is stated in count 1 and also stated in counts 7 and 9. Were used up, were subsumed, and would be therefore, would effectuate a merger of those crimes. In either event, this court has wide discretion in how it fashions this sentence. And we'd ask the court to exercise this discretion in favor of growth, in favor of redemption, in favor of hope, for not just the McMichael family, for not just Everett McMichael, but for the Arbery family and what Travis McMichael can prove himself worthy of in the future. Thank you, Your Honor.
Thank you. All right, I think we're probably at a good breaking point. Let's go ahead and take a break, let everybody get some lunch. We will plan on reconvening at, let's do 1 o'clock. It's just before 12 o'clock now, and we will continue with proceedings at that time. Thank you, everybody.
All right, so lunch break. This is going to be, as they believed, most of the day sentencing hearing. Amazing, amazing things that we have heard from today. First, I want to go to Joey Jackson as our expert panel. Joey, the victim impact statements were amazing. They were emotional, 3 of them altogether, but the mother of Ahmaud Arbery respectfully addressed the judge, but talked to her son as she was giving this victim impact statement.
Has to be so difficult, Gene, and
All right, we're back on. We're missing one. Mr. Rubin, I guess.
Your Honor, Mr. Sheffield unfortunately had other business he had to attend to.
His impersonations, his warm smile.
All right, we want to take you back into that courtroom live right now. All the parties are assembled. Let's listen.
Travis McMichael had completed his presentation to the court. From Greg McMichael.
Your Honor, I want to begin by just addressing some case law that seems to apply to the, I want to say, piling on of the additional felonies, and that they do not merge, which is the state's position. I point the court to Noel versus the state, 297 Georgia 698, a 2015 case. And it says, in fact, what Ms. Dunikoski's position is, that the additional felony murder counts will be vacated by operation of law when they involve the same victim. But in that case, there was, as there is in this case, additional felonies, which in Noel, there was a question about whether the trial court should have also sentenced and not merged those into the felony murder counts, which were vacated by operation of law. I want to make a separate argument. This is the first time we heard of this morning. I know of no law that prohibits the court from conducting merger before the vacating of the by operation of law. So in other words, if you were to merge the underlying felonies into the felony murder counts, and then those counts are vacated by operation of law, we don't even need to consider this. But in Noel, this Georgia Supreme Court case, this court concluded that the trial court had failed to sentence on the underlying felonies that were the predicates for those felony murder counts that were vacated by operation of law, but did not automatically say that the trial court erred in not sentencing on those. In Noel, the Supreme Court ordered the trial court to make a determination, and I quote, whether the remaining non-murder felonies merge as a matter of fact into the felony murder conviction, and that's why the case was remanded back. And interestingly, in the Noel case, the Hewlett case is cited, 296 Georgia 49. That's a 2014 Georgia Supreme Court case. Same issue as before about the felony murders being vacated by operation of law. And then but in Hewlett, it was a malice murder case as well. But it gave some instruction, and I suppose that's why the Noel court relied on Hewlett, gave some instruction about whether there would in fact be merger. And in Hewlett, the important distinction was whether the felony that then led to felony murder was followed almost immediately by the death of another. So the question was whether there was a, quote, deliberate interval between the offense and the death. For those reasons, Your Honor, I ask the court to find as a matter of fact that those felonies do merge and that there is no reason and no statutory obligation for the court to sentence on the other remaining felonies that the state wishes to proceed on.
So I understand what you're saying. What you're saying is there's no deliberate interval then, because there are some other cases.
Yes, I'm sorry, I just realized that I put that. Yes, that's exactly what I'm saying, Your Honor, that all of this took place in a continuing manner, that there was no stop and start between the beginning of the chase, we'll call it, and the end, which led to the tragic death. So for that reason, I think that it can be distinguished from some of the other cases that Ms. Dunikoski may be relying on. But it certainly stands for the proposition that simply because the felony murders are vacated by operation of law does not mean that the underlying felonies have to be sentenced upon. They don't still exist. They aren't still there. There still is a question of merger by operation of fact.
Okay, understood.
All right? So, between the two statutory sentencing options that are before this court, the state is asking for the sentence of life without the possibility of parole. And grab this. They made that position known back in September of 2020, specifically September 16th of 2020, when they filed a notice of the state's intention to introduce evidence in aggravation of punishment. And in that notice, Your Honor, under the final box that's checked, the state indicated that it intended to seek life without the possibility of parole by relying upon three statutory code sections: 1651, which is simply the murder statute; 1710-2, which is the statute of criminal procedure that provides for what we're doing here today, the presentation of evidence in support of any sentence that each party is seeking. And finally, 1710-6.1 is the third code section on which the state relied in seeking life without the possibility of parole. And in that code section, that is, as the court knows, sets forth the inability for any individual who is incarcerated for the first time on an aggravating, on a violent felony, which results in a sentence of life with the possibility of parole, to not be considered for any form of release or parole until after the service of 30 years in prison. Those were the reasons the state said, we seek punishment of the defendant in this manner. And at the top of their notice of seeking aggravation of punishment, the state indicated in September of 2020 that they intend to introduce evidence of any convictions, juvenile adjudications, and other crimes of the defendant furnished as part of the reciprocal discovery. What the court knows is that there are no other crimes and no other pieces of evidence that support that statutory ground for seeking aggravation of punishment. So in the absence of that sort of evidence, which is the evidence the state indicated back in September it would provide, an absence, as the court knows from the bond hearing and having had those documents provided to it, there is an absence of any criminal history by Greg McMichael, which is a significant factor in your consideration of what sentence to impose. So, without any of the aggravating evidence that was set forth in the notice, the state has told this court now, we wish to simply rely on the facts of the case. And in particular, what Ms. Dunikoski argued is, number one, what she called a pattern of vigilantism. But every example she gave, Your Honor, was not, in fact, vigilantism, gathering up folks who have no authority to do so and taking the law in your own hands. Her examples were notifications that Greg McMichael made to law enforcement about suspicious activity and suspicious people in their neighborhood. And In fact, that is exactly what a neighborhood watch program is all about. That's what Officer Rash testified to you we need, we can't survive without neighbors who will let us know what's going on and provide us the evidence we need to investigate crime. Very different and not at all related to some sort of pattern of vigilantism, which is a violent act. The second fact on which the state said that they were relying, based on the facts of the case, to seek an aggravation of punishment from a life with parole, meaning no consideration for anything less than 30 years, all the way up to life with absolutely no window of opportunity, is that Greg McMichael has shown no remorse or empathy. The difficulty of our adversarial system, a system that is the best system we know of, is that it still leaves no opportunity for an accused to turn and be the person you know he's been for 30 years, for 66 years, and offer condolences to another person for their sadness and for their loss. The other problem with the adversarial system that I know all too well is that an individual who is committed to telling the stories, to explaining to a jury how an individual got where they are right now, often feels like a defense attack on the surviving relatives of this loved one. A vigorous defense often results in the sadness of people who have lost a loved one. But those are the roles that we honorably take on. Our remaining stoic in the face of heartbreaking testimony this morning from people who have lost a loved one is because that's our role in this courtroom. This court has very handily taken care of emotional outbursts to make sure that we're dealing with law and facts and not the kind of thing that can otherwise affect a court or a system that should remain free of those sorts of emotions. So, Your Honor, like Mr. Rubin said, it really isn't anything that I suspect the court will be taking into consideration, the fact that Greg McMichael didn't and couldn't stand up and offer his genuine sadness and condolence for the loss of a loved one, because he's facing other crimes. He's facing charges and trials on other crimes, criminally and civilly. And I hope the court knows that what we need to do to tell his story in any case involving justification, of which there was sufficient evidence to move forward with a request to charge, is that there has to be a clear, palpable, full-throated explanation to a jury about how it is that an individual put himself in a place where our clients felt they had to defend themselves. It must be terribly difficult to hear when it concerns your loved one who's no longer here. And it probably feels cold. But the court knows those are our roles, and it's the only way to make sure that our system operates as it should. So, Your Honor, with no statutory aggravating circumstances, like in a death penalty case, how do you decide? We now know there are no statutory aggravators based on the notice. We now have told you about how the factors that the state said arise out of the trial actually escalate this out of life with parole to life without parole. I suggest to the court that we rely on a wonderful system that the federal United States sentencing guidelines set up and the United States Code, and that's you look at two things. You look at the nature and circumstances of the offense, and you look at the history and the characteristics of the defendant. Let's talk, number one, about the nature and circumstance of the offense. The best indicator of what happened in order to respect the jury's verdict is to listen to the jury's verdict. The jury found that Greg McMichael, as a party to the crime, committed felonies that unintentionally led to Ahmaud Arbery's death. After deliberating for over 10 hours, over 2 days, they came back with a unanimous verdict that says, in effect, Greg McMichael did not leave his home that day hoping to kill. He did not view his son firing that shotgun with anything other than fear and sadness. What this jury found is that this was an unintentional act, one that Greg McMichael did not plan, devise, attempt, or seek to have the result that happened. So if life without parole is a sentence that is held for only the worst of the worst, it simply can't be a sentence for a person who never intended that tragic result that took place on February 23rd. If you never wanted another person to die as a result of activities you took part in, you can't be the worst of the worst. Secondly, Your Honor, under 1710(2), the things that this court should consider, you should take in account extenuating or mitigating evidence that you heard in trial. Heard in trial based on the presentation of evidence over several days that Greg McMichael sought to detain Ahmaud Arbery for one reason and one reason only. It was not for sport, it was not for evil, it was for the same reason that the police who repeatedly came to Satilla Shores came there for. It was to get to the bottom of Ahmaud Arbery's nighttime intrusion into Larry English's house. The verdict spoken by this jury, based on their understanding of the law of citizen's arrest, found that Greg McMichael did not possess the information he needed to possess to attempt to execute a citizen's arrest, and that meant that Travis was not in a position to defend himself because he was the initial aggressor, if there was no citizen's arrest that could be supported by the facts and the law. That is the offense that you heard. A reason that is not an evil reason, not a reason of hate, not a reason of anything other than trying to help other people to get to the bottom of this inquiry. Further support of extenuating and mitigating circumstances from the trial you saw in the video itself. As painful as it was to watch, I'm sure the court does recall that when you saw Greg McMichael in the back of the pickup truck, in the bed of the pickup truck, not directing, not doing anything that's going to be the person who's advancing the progression of this from the chase, the attempt to stop and detain Ahmaud Arbery, into what it ultimately became, you most importantly saw that Greg McMichael never even sought to remove his handgun from its holster until after you heard the first shot. the first shot that took place in front of that pickup truck. So while he's on the phone begging for 911 to come and help, that is the moment he removed his handgun and never fired a shot. That is the nature and the circumstances of the offense that this court heard and upon which the jury reached their verdict. So now, the history and the characteristics of Greg McMichael. Because we know that history is the only reliable measure of a person's character. Greg McMichael is 66 years old. So, Ms. Dunikoski, there has not been just 99 good deeds, but more like thousands and thousands of big and little good acts of kindness, charity, goodwill throughout this man's life. Greg McMichael is a good man. He's not a perfect person. None of us are. But he's lived a good life, a life dedicated to service. And that does count for something. The choices he made as a young man, all the way through the rest of his life, to serve, not to acquire wealth, not to do anything that brought extreme attention to himself, but to quietly go through the business of choosing career options to help other people. You heard at the bond hearing and during the trial of this case, Greg McMichael chose as a young man to serve this country by enlisting in the Navy. And after an honorable discharge, some years later decided to serve his community. Over 30 years in law enforcement. He was not a patrol officer, then later a detective, then later an investigator with the DA's office because he sought power. There was no evidence of anything like that. There were never any complaints about him being aggressive, about him seeking to take matters in his own hands without seeking the appropriate backups. He was not a gun-toting, aggressive officer. His wife testified during the bond hearing. One matter of pride that Greg McMichael always had is that he never had to discharge his weapon during the service of his community. And of course, he wasn't a law enforcement officer or an investigator for the DA's office for money. That's laughable. He did it to help, he did it to serve and protect other people. His post file that the court had into evidence during the bond hearing indicated numbers of commendations and notes from people in the community indicating how grateful they were for his willingness to participate in a case, for his willingness to go the extra mile, for his kindness to families of people who had lost loved ones. Things that are above and beyond the work that he needed to do. Those examples of commitment, of empathy and kindness are further examples of who Greg McMichael is. He is a husband for over 38 years through thick and thin to the woman that he met and married months later. He's a son, a brother, a father, and a devoted grandfather. So yes, that's how I stand before you, Your Honor, representing Greg McMichael, who has now been convicted of murder, and I say without hesitation, he remains a man of goodness. For 66 years, I calculated that's 24,105 days of life on this planet. And we're here not for a small matter, not as if all of the other erases what happened on that day, but we are here for a driveway decision to pursue Ahmaud Arbery and a 5-minute chase that ended in tragedy. He needs to be punished. But how that contrast between a life of goodwill and service and the bad decisions that were made that day that resulted in a tragedy that the jury said unanimously he never intended could end up in the state seeking the sort of sentence that is devised for the worst of the worst is not consistent. In many courtrooms, Your Honor, that I appear in, right behind the judge, and it might be that way in Chatham County, there is the seal of the state of Georgia. And our Georgia state seal has 3 words on it: wisdom, justice, but most importantly, moderation. Life without parole versus life with the possibility of parole may be nothing more than academic for a 66-year-old man with significant health problems, because it means 30 years, at the very least, in prison. But it is an important distinction. It will affect all sorts of other things that could happen to Greg McMichael while he's in prison. But most significantly, it is the only way, Your Honor, to honor the jury's verdict that Greg McMichael committed crimes for which he never intended the result. For that reason, for the lack of evidence of aggravation, for the presence of significant evidence of extenuation and mitigation, we ask the court to sentence Mr. McMichael to life with the possibility of parole. Thank you.
Mr. Goff.
Your Honor, we're going to need a short recess before we proceed. I need to triple check a matter.
Okay.
A 5-minute recess should be sufficient.
All right, well, let's make it realistic. Let's take a 10-minute recess, and then we'll come back on the record at 1:45. Thank you.
All right, so there you have it. The argument by the attorney for Gregory McMichael. Very strong, very passionate, saying that the jury, look at what he was convicted of. He was not convicted of an intentional crime, and therefore that deserves the possibility of parole. Joey Jackson, your thoughts on this as a defense attorney, as she is passionately giving all of the reasons of why there should be a bit of leniency at this point?
Yeah, I certainly, get and understand where she's going. And as a defense attorney, certainly you have the facts that are there. What I don't like or would ever appreciate, and I don't think a court does, is a relitigation of the matter. The jury has concluded what they concluded, notwithstanding what your personal view or agreement or what you urged upon that jury that they rejected. However, having said that, Gene, I think that if you look at what he's convicted of, that is her client, Greg McMichael. If you look at the issue of intent, I think that plays big, right? When it relates to felony murder, you need not have the intention. If a death occurs and there is an underlying felony, like aggravated assault, like the fact that you're either kidnapping or engaged in some conduct to otherwise confine him, false imprisonment, right? Then you have what you have is felony murder. And so certainly the issue of intent is something that is very relevant to the judge. In addition, and finally, the issue about considering her client's life in the spectrum of his now 66 years and all the other things that he may have done, and not measuring it by a snapshot in time. However, that snapshot in time is very significant. I do like the fact that she really related it to these federal rules, and these federal rules of evidence suggest that you look at the nature of the offense and you look at the individual's background, etc., and that's what she did. At the end of the day, though, Gene, let's be clear and real, and you brought up the greatest point of all. Given the fact that he's 66, even if her argument carries the day, even if the judge says, I do agree with you, and that weighs heavily, there was not intent. I agree with you, he has used his life in many other instances for kindness and goodwill, and the judge says, okay, 30 years, 66 plus 30, 96, what real headway did you make? And the realities here are just harsh. The leverage she has is very minimal. And I think, she's darned if she does, darned if she doesn't. Her client is facing a world of hurt momentarily when the judge pronounces his sentence.
Ms. Damaris, let's go forward.
All right, we're back on. Defendants present, represented by counsel. Mr. Goff.
Your Honor, let me begin by making clear that nothing I say should constitute a withdrawal or abandonment of any other sentencing-related or punishment-related motions previously filed. Beyond that, if this were any other case, when it comes to sentencing, I'd be turning to Ms. Donikoski and saying, Judge, what she said. I agree in a lot of ways that the sentence recommended by the state should be the judgment of the court. But this is not a normal case, and out of an abundance of caution, I do feel like I need to address a few issues, but I'll be relatively brief. And there is one issue that the state's sentencing recommendation did not address. I'm pretty sure I know what the answer would be. It won't take them long to give it, but I would put it on the record. Your Honor, like Travis and Gregory McMichael, Roddy Bryan is a first offender. He has no prior felony convictions. Like Travis and Greg McMichael, Roddy Bryan has lived a life, however well lived, that warrants an opportunity and potential for redemption and rehabilitation. I would ask the court to consider the entirety of the record in the case, including the transcripts of the pretrial proceedings, including the bond hearing in this case. I'm not going to go through a whole bunch of Roddy's family history and circumstances. I know the court is familiar with them. The McMichael defense teams have argued elegantly and persuasively for sentences of life with the possibility of parole, based on the grounds that I've previously discussed. And like the McMichaels, there's no evidence that Mr. Bryan is depraved or among the worst of the worst, and therefore Roddy Bryan should likewise be allowed the possibility of parole. And there is an argument here as to whether or not the life without parole option is an option before the court in this case. I didn't think the state had filed a notice of intent to seek life without parole, and apparently they did file the notice. I'm not sure whether they had intended to withdraw the notice beforehand or what happened, but in this case, the notice, which I don't recall receiving, was filed in September 2020. It was emailed to a Sea Island address, not mine, which would be consistent with it not having been properly served. And I would take the position that due to a technicality beyond the control of the state in this case and beyond the control of the court, and the service was by the previous Chief Assistant, Jesse Evans, in this case, that technically, not having been served as provided in the certificate of service, that the notice is defective. There still remains an issue as to whether the court can impose sentence anyway without that notice, and that would require the court's resolving two competing statutes. You have the sentencing statute itself, and then you have 1716-4 under which the notice was provided. We would suggest a rule of lenity indicates that where the notice has not been served, or there's not proof of proper service, that the court doesn't have discretion to impose a sentence of life without parole. I'll let the court think about that. It may be an academic question anyway, particularly given the state's recommendation, which we're certainly not going to disagree with. But going beyond that issue, Your Honor, while Mr. Bryan is also a first offender and also worthy of rehabilitation based on the life that he's lived, as the evidence reflects, that's where the similarity between Roddy Bryan and the McMichael defendants ends. And I would submit to the court that that isn't the beginning of the sentencing inquiry for Mr. Bryan, the end of the sentencing inquiry for Mr. Bryan. I would respectfully submit that it's the beginning. Now, before getting into that, I do want to address one other. Lawyers probably shouldn't use the word technical arguments, but I would contend that count 9 merges into count 8. I don't think alleging separate streets that the chase is occurring on changes it if someone was chased through the city of Savannah. I don't think that you could argue that there were 15 different attempts at false imprisonment or 15 different false imprisonments. If you went down Montgomery and up MLK and across Broughton and up the President and down Julian, I don't think you could multiply counts that way. I do think that 9 is an inchoate offense that obviously merges into 8. And because the motor vehicle that was used in this case was used in the context of the chase, there's a factual merger. And I think it's more or less the same argument that Ms. Hogue was making, but I could be mistaken. And so I want to adopt her argument as well to the extent it's expansive beyond mine, and specifically a recitation of the Knoll and the Hewlett cases. Having done that, I want to get into what I think is where the sentencing inquiry for Mr. Bryan really begins, because this is a kind of unusual case. To me, there are 4 additional factors that the court has to consider in fashioning a sentence here. And then the question becomes how the court does that under the laws of our state. We've already challenged those laws. The court, not surprisingly, given prior decisions of our Supreme Court, whatever standards may be evolving until the Supreme Court says they have, this court applies the law that we have. But there are 4 factors here that I think the court has to the court never has to consider anything I think the court should consider. Issue number 1 is the jury verdict says that Roddy Bryan was not a party to the shooting, nor a shooter. Roddy did not kill Mr. Arbery. He did not attempt to kill Mr. Arbery. He did not intend to kill Mr. Arbery. He had no idea that the McMichaels had guns until moments before the shooting. And that's not just an opinion, that's pretty much a jury verdict. When they acquitted Mr. Bryan, not only at count 1, but also count 2 and count 6, when they found him not guilty of anything related to the shooting, that's a reflection of the fact that Mr. Bryan had no idea of what was about to happen. That tragedy was certainly not something that he could have anticipated up until the moments before. And by saying that, I'm not trying to get back into the charge conference issues. It's a different factor here at sentencing. But Roddy Bryan was not a vigilante. He was not a party to any organized effort to fight crime in Satilla Shores. Roddy Bryan really had no idea what was going on or why until after the tragic death of Mr. Arbery. And I think the state pretty forcefully drove that issue home during its closing argument in this case. That factor really puts Mr. Bryan in a different position. Mr. Bryan isn't the one who brought a gun. He was unarmed. And I think that reflects his intentions and it reflects a significantly lesser state of culpability. The second issue, Your Honor, is the issue of remorse. Now, like the McMichael defendants, Mr. Bryan faces a federal trial and substantial federal penalties in the event of a conviction. I would agree with Mr. Rubin that no competent attorney in the state of Georgia under these circumstances would allow a defendant to say anything more than they already have. But in this case, distinguishing again Mr. Bryan from the McMichael defendants, Mr. Bryan has expressed remorse. Whether it's part of the record or not, he expressed remorse about Mr. Arbery's death even before he was arrested on national television. As the Arbery family, of course, has not accepted that, and they don't have to, Your Honor, and we can all understand why. But beyond that, when you look at his statements in this case, I think it is readily clear that while Mr. Bryan has disputed and continues to dispute whether things that he did that day constituted crimes, he has never questioned the tragedy of this death and has never expressed anything but remorse over the death of Mr. Arbery. And that does put him in a very different category, I would submit, and a very different posture from the other defendants. And I would remind the court, and I'm not going to spend a lot of time on it because the court heard most of this, but during the trial, the court heard the body cam from Mr. Minshew. Mr. Bryan admitted from the get-go that he chased after Mr. Arbery,
that he was uncertain as to whether they should have done that. He wasn't running around the scene trying to influence witnesses' testimony, as the state alleges other people have done. He was very candid and straightforward, and you heard his demeanor on the video at the crime scene. You heard the excerpt from the interview with Detective Lowry, and of course the court has the entire statements in the record, where Mr. Bryan expressed, again, regret that Mr. Arbery died. He pointed out that, if his vehicle had collided with Mr. Arbery, maybe Mr. Arbery would still be alive. And not in the context of wanting to hurt Mr. Arbery, but in the context that maybe he would still be with us, and this tragedy might have been something less. Beyond that, Your Honor, there were a number of statements made to Investigator Sechrest, Special Agent Sechrest, during the investigation of this case, which technically, I believe the statements themselves, the transcripts and the videos were admitted into evidence at the Jackson v. Deno hearing. At least that's my practice. I don't have a transcript to look at, but that's normally what I do. And moreover, I think they were tendered in connection with the preparation for the trial itself, and I think technically during the trial, although they weren't presented to the jury, but the court can consider those. On May 11th, Mr. Bryan, I'm referencing page 69 of that transcript, indicated that he did not want to see the video in the aftermath of the shooting. He didn't enjoy it. He didn't take any pleasure in that. On May 13th, at page 75, Roddy Bryan expressed shock to Agent Sechrest at the shooting of Ahmaud Arbery. Referencing page 100 of the transcript, Roddy thought it was that what Mr. assumed, thinking might be putting too much credit to Mr. Bryan, Roddy Bryan assumed that Mr. Arbery had done something more serious, that there was more to it than going through an open, unsecured construction site. And that doesn't change the lawfulness or unlawfulness of his conduct, but it does reflect on his level of remorse. At page 101, Mr. Bryan says that to Agent Sechrest, and these are all statements that the state could have used at the trial against him had they wished to do so, and may still be used against him in federal court. None of these statements are without consequence. That he was sorry that Ahmaud Arbery died, that he wished he had stayed on his front porch. He's not going around boasting to people or bragging about it. He's regretful way back then. And that is before he was arrested. At page 102, he regretted having got involved in the chase. And, Your Honor, I think when you take those statements in conjunction with the rest of the evidence in this case, Mr. Bryan has done everything he could do, short of confessing to committing felonies on national television, that he is remorseful and regretful at this tragic loss of life. And it's difficult for me to conceive what more he could do. Now, is the Arbery family going to be satisfied with that? No. They don't have to be satisfied with that. You have to give credit. 3 members of his family came up here and probably did what were the most difficult things they've ever had to do, is to come speak here in this court on national television effectively about the death of their child and their brother. And that's difficult. But whether or not they accept Mr. Bryan's expression of sorrow and remorse for the death of Mr. Arbery, it's for the court to decide whether Mr. Bryan has expressed remorse, and if he has, what to do about it. And the court may well decide there's nothing the court can do about it. The felony murder statute prescribes one punishment, a mandatory minimum of life. And I'm not reviewing the legal argument there. But if there's a way the court can take it into account, I'm going to argue that the court should. The last issue, Your Honor, and I think the court is well familiar with it, is Mr. Bryan's full cooperation with law enforcement from day one, from moment one, from minutes after the shooting. I'm not going to belabor all the different things Mr. Bryan did, producing the cell phone, the night out video, the numerous statements, going through the area where the shooting took place with the police to help them understand what happened that day. On a scale of cooperation mean, you'd have to put Mr. Bryan at a 10 out of 10, even a 12 out of 10. I've never seen a defendant provide that kind of cooperation. Most of it without the benefit of counsel. Slick lawyers didn't tell Roddy Bryan to turn over the cell phone, to talk on the scene on the body cams, to go down hours later to the police department. Roddy Bryan did that because he wanted the truth to be known, whatever that was, whatever it meant. So these are all factors above and beyond anything that apply to the McMichael defendants as to why Mr. Bryan should receive a lesser sentence. Now, the mandatory minimum in Georgia is life imprisonment on a felony murder. I'm not going to rehash the legal arguments. What I am going to suggest to the court, though, and given the age of the defendants here, whether Mr. Bryan is eligible for parole or not, he's going to be 80 years old under the current guidelines before he could be eligible for parole. And effectively, even if the court grants life without parole sentences, as the state has requested, to the McMichaels, simply giving Mr. Bryan a sentence of life with the possibility of parole, still, given the respective ages, means that he would essentially serve the same sentence and that there would be no options there. So I'm asking this court to consider sentencing Mr. Bryan and Mr. Bryan only under OCGA 17-10-1B, which, at least in my experience, is relatively rarely employed, but perhaps underused, especially given the evolving standards of, with respect to sentencing issues. Under 17-10-1B, as I understand it, a request for relief from parole restrictions may authorize consideration by the parole board of parole prior to the completion of any specified time period otherwise required prior to parole eligibility. Imposing sentence under this statute does not grant Mr. Bryan parole. He still may never receive parole. He could still die in prison 50 years from now, even if the court grants relief under 17-10-1B. All that does, however, is it gives the parole board the freedom, if you call it that, the ability to parole Mr. Bryan whenever they see fit, regardless of any statute or rule that would otherwise prevent it. Now, Mr. Bryan still has a long road here to establish the redemption and the rehabilitation that would justify his ever being released from prison. So, as I've explained to Mr. Bryan, this doesn't guarantee him that he would do 1 day less in prison than he would otherwise do under the sentence that the court is about to impose. But what it does do is provide the opportunity for the parole board to exercise its discretion in deciding whether to release Mr. Bryan when they believe it would be appropriate and not based on some arbitrary, preconceived, mandatory minimum time period before he could be considered. And I believe that this is that rare, exceptional case where relief under 17-10-1B, however fleeting it might be, depending on the circumstances, that this is a case where that would be appropriate. And I would respectfully submit to the court that as a practical matter, it is it's really the only relief that the court can give Mr. Bryan to reflect his cooperation, his expression of remorse, and the other factors that I've reviewed with the court today. And that doesn't change the sentencing recommendation. I'm concurring with the state, putting aside the legal arguments about merger and vacating of sentences. I'm agreeing with them that the sentence of life plus 15 consecutive probation, that would be the appropriate sentence in this case. I think the only thing that we really are disagreeing about at this point is I'm expecting the state is not going to be excited about 17-10-1B, but I'm asking the court to do that anyway. And in this relatively small instance, and again, it may be completely meaningless depending on how the parole board views things 10 and 20 years down the line, but it is really the only thing short of striking down parts of Georgia's sentencing law on constitutional grounds, it's really the only thing this court can do that would substantially reflect the wide chasm in differences in culpability and other issues between Mr. Bryan and the McMichael defendants. It's really, it's all that this court really has available to do that. And if for no other reason, that's why I would ask the court to do so. But I do think it would be in the best interest of justice. I mean, Your Honor, Roddy Bryan probably, I won't say he's unique, but he's pretty as close to unique as you can get in our criminal justice system. It's a felony murder for someone who didn't kill or attempt to kill or intend to kill, and it's in the context of a citizen arrest. However foolish and badly guided and misinformed, and certainly however unjustified under the law, there probably isn't another individual in the entire Georgia prison system that's in a similar posture. And thanks to the changes the legislature has made to the citizen arrest statute, it will certainly never be an issue again. So this is a request that we're making here on behalf of Mr. Bryan that would effectively impact one person now or in the future in the state of Georgia. And we're not asking that as special treatment for Mr. Bryan. We're asking it as treatment that anyone in his situation would be asking for, given the totality of circumstances present to the court. So again, we're asking the court to impose a sentence of life imprisonment plus 15 years, but we're also asking the court to grant relief under 1710(1)(b). Thank you, Your Honor.
Thank you, Mr. Goff. From the state.
Thank you, Judge. Because there's a number of legal issues as well as additional argument by the state, is there any particular order you'd like to hear it in? Would you like me to start with Mr. Bryan first and work backward, or just go from Travis and...
Why don't we, however the state wishes to present it, I'll be able to follow it, I would imagine.
Wonderful. Okay, Judge. So regarding Mr. Bryan, with regard first to this parole board issue, 1710(1)(b) actually says that it will apply only to first offenders, where technically Mr. Bryan is a first offender. He doesn't qualify under the first offender statute because anyone convicted of felony murder, you're not allowed to sentence them under the first offender statute. So we have that problem first. But the second problem is that it refers back to A. And subsection A of 1710(1) actually says, except in cases in which life imprisonment, life without parole, or the death penalty may be imposed, and then goes through. So B can't even apply to anything that imposes a life sentence. And that's how the state is reading this, because when you look at B, the judge, in fixing the sentence as prescribed in subsection A of this code section, subsection A says except for life sentences. So therefore, none of this will ever apply to a felony murder conviction. And then looking at count 9 merging into count 8. I understand factually the issue that Mr. Goff has brought up on behalf of Mr. Bryan, that two separate instances, one an attempt to confine him taking place on Burford, was just a continuation of something that was going on and on and on and on. Ironically, that was not the argument that Mr. Goff made at trial during his closing argument. He actually started to posit that Mr. Bryan was actually leaving and wanting to go home and just happened to go in the wrong direction back down Holmes, and that he wasn't actually trying to commit a false imprisonment on Holmes. He was just trying to go home. But regardless, what we have here is an intervening factor. I didn't know Mr. Goff was going to make this argument, but I believe there's a case out there that involves aggravated assault and aggravated battery. And it involved a man who had cut the female victim's throat and then also cut her face. The aggravated battery was on the face, the aggravated assault was on the throat, but there was an intervening time frame. And so on the one hand, I do know that there are numerous cases out there where if you start shooting at somebody and then continue to shoot, it's all one aggravated assault. Okay, there aren't separate aggravated assaults for each time you fire, unless there is an intervening actual time frame where you've shot, they've run away, you've chased them down, and now you're over on another street, like we have in this case. You've encountered them again, and now you start shooting again. Because there's two different locations, two different specific places and times, that allows the state to charge it. And the reason it allows the state to charge it is because what you're really trying to do is prevent the state from engaging in double jeopardy. You don't want the state to be able to go on January 3rd on Burford, no, on, well, I'll do our case. On February 23rd, 2020, on Burford, you attempted to falsely imprison him. Oh, not guilty. Okay, well, we'll go ahead and move it over to Holmes, and we'll get a new indictment, and we'll do it over there on that date. So you want to keep the state from going ahead and doing two different things in two different bites of the apple. You want to make sure there's no double jeopardy here. Well, in our case, we don't have double jeopardy here because we have two different separate instances, and they're both in this indictment, and they're both two separate time frames. Yes, very close in time, between 4 minutes. I know I'm kind of giving the court both the defense side and the state side, but to be candid with the court, there are cases out there, especially the gunshot cases, that say it's all one continuous action. The state's position in this indictment, and one of the reasons we specifically indicted it this way, is because Mr. Bryan's attempt at false imprisonment on Burford was specifically done with his pickup truck when he tried to run Mr. Arbery off the road and tried to attempt to falsely imprison him right there with his truck. He attempted 4 different aggravated assaults on him at that point in time to get him to stop there. He was unable to do it. That's why it's a criminal attempt. However, over on Holmes, after he went up and chased him up, and then we begin the video, and Mr. Arbery turns back, Mr. Bryan does continue to go up Holmes. He actually goes up Holmes. It's on video. He pulls into a driveway. He says, I'm going to go ahead and keep going. He does a 3-point turn, and then he comes down Holmes. He encounters then Mr. Arbery coming around the corner, and that is where that actual false imprisonment absolutely takes place, right there on Holmes, where Mr. Arbery is ultimately falsely imprisoned and killed. So these are two separate, distinct incidences, and there is no chance of double jeopardy because both of these things are distinct. They took place at separate places and separate time frames within the incident. So we ask that count 9 not merge into count 8 for Mr. Bryan.
I'm sorry to interrupt. I'm not sure because of the way we're doing this. I did want to point the court to another case with respect to this issue that's been drawn back to the merger issue that I raised, and that is, the point is whether or not it's a continuing offense. Kidnapping is a continuing offense. So, for example, if someone is moved, an asportation occurs, all the places during that movement are one crime. And I'll cite to the court Hill versus the state, 279, Georgia App 666, a 2006 case that's cited in Brower versus the state, 298, Georgia App 699, a 2009 case. It says that the offense of kidnapping is complete when, in this instance, Brower sees the victims, forced them to the back office in the case of the office staff, and when he taped up and moved the attorney from place to place in the office. So the movement is the question is, if kidnapping is not a continuing offense, then is false imprisonment, and I've done a search and I just don't have the answer to that.
And, yeah, we'll keep the state to its argument. Understanding that with the kidnapping, the issue here, I think, is slightly different. As I understand what the state's arguing is the way that false imprisonment and the attempt was alleged in the indictment was that the attempt occurred on Burford. There was an intervening interval, and then later, short period later, but later, there was a completed act on Holmes. Okay, that's the argument that I understand is being presented, and that's the way I'm going to look at the merger part of it. Now, how that fits and whether or not it merges, I'm probably going to take a few more moments to think that through and how that works. But that's what I understand we're looking at as far as the legal issues. And I understand the kidnapping part of it. You have a kidnapping, just because you move them within the office, we're not going to allege it. Flip side of that is, I mean, you look at some other statutes like I won't tip at windmills, but when you look at police chases, I mean, you can be charged with obstruction 5 times in the same chase. So, I mean, the issue may seem simple, but it's not. But this is the way I'm going to approach it. Okay.
Thank you, Judge. And I believe the reason for the merger really comes down to the issue of double jeopardy, because you have to put the defendant on notice, because you do not want there to be an opportunity for the state to come back with double jeopardy, which is why you want to get as specific as possible, and which is what we did in order to designate these 2 separate instances in time and in place. So that is the state's argument as far as count 9 merging into count 8. And that is what I have for Mr. Goff. Now, Your Honor, with regard to the legal argument that Ms. Hogue made on behalf of Greg McMichael, actually, Noel was then cited in the case of Jeremy Scott, who killed Dexter Holliday. It was a Fulton County case. Embarrassed to say it was my own. And in that case, we had to resentence Mr. Scott because what the court did was sentenced him on the felony murder conviction, but then actually when he was found guilty of possession of a firearm by a convicted felon, the court went and took the possession of a firearm by a convicted felon, merged it into the felony murder, then merged the felony murder into the felony murder for the armed robbery. And the court went and cited to Noel. And this is Scott versus the state, 302 Georgia 29. It's a 2017 case. The state notes that based on Noel versus the state, the trial court erred in merging the felony murder convictions and then merging the predicate felonies into the remaining murder conviction. When the trial court sentenced Scott on count 2, the felony murder based on aggravated assault, count 3, felony murder based on possession of a firearm by a convicted felon, was vacated by operation of law. Therefore, count 6, possession of a firearm by a convicted felon, then cannot merge into count 3, which stands vacated. We therefore vacate the merger of count 6 into count 3, meaning the possession of a firearm by a convicted felon, into the felony murder that it's based on, and remand for resentencing on count 6. Now, factually, you are a convicted felon at the moment you're shooting that person. It happens at the exact same time. So I think that kind of goes towards that, well, if it's all happening at the same time, it needs to merge together. And I will also direct the court to a case I affectionately call the El Camino case. Once again, unfortunately mine. This is DeMarcus Graves. It is Graves versus the state, 298 Georgia 551. Once again, a 2016 case. And at that point in time, basically it said, while the evidence was sufficient to sustain Graves's conviction, we find an error in sentencing. The trial court purported to merge 2 felony murder counts with the malice murder count. The trial court then purported to merge 2 independent felonies, criminal attempt to commit armed robbery and possession of a firearm by a convicted felon, with the 2 murder counts. And basically what they said in Graves was, no, you can't merge the felony murders into murder. You have to vacate them by operation of law. And once they're vacated by operation of law, that's going to leave you with the possession of a firearm by a convicted felon and the criminal attempt to commit armed robbery. Therefore, the trial court is required to vacate that portion of its sentencing order purporting to merge the 2 independent felonies and impose proper sentences on those counts, which I then had to go ahead and do and resentenced Mr. Graves to the murder charge with those 2 particular felonies. So there are 2 cases right there that show that that is not the case, because they murdered Mr. Graves while attempting to rob him of his drugs while he was sitting in his El Camino in the parking lot of an apartment complex while being convicted felons. All of that took place at the exact same time. So therefore, Noel does not stand and has been overruled basically by Scott and Graves. So with regard specifically now to Greg McMichael, the idea that there was no vigilantism here because after they confronted people, after they took their guns to confront people, after they confronted those people with those guns, then they would call the police, is somehow a neighborhood watch situation. As Officer Rash testified, they're supposed to be witnesses. That's what Neighborhood Watch is there for. They're supposed to be great witnesses. Officer Rash said he thought Greg McMichael would be the best witness, being a prior law enforcement officer, that he'd be able to come in and take the stand and say what he saw. That's what Neighborhood Watch is supposed to be, not somebody running after people in a residential neighborhood where there are women and children and people out walking on a regular basis. This was a Sunday afternoon. It's a miracle they didn't run into families taking a walk that day. And on a random day, when the GBI went out with the drone videos and were just going through the neighborhood, they captured numerous people out taking a walk. A family with children were there. So the next point, that Greg McMichael has shown no remorse or empathy because he's unable to. Well, Greg McMichael was a law enforcement officer. But what he did on May 5th of 2020 was release evidence in an ongoing investigation into himself and to his son. Greg McMichael's the one who released the video to the media. He went to Mr. Bryan and said, hey, give me your phone, I'm going to take it to my lawyer, took it to his lawyer and had his lawyer release it publicly because he believed it was going to exonerate him. That's interference with administration of justice. Yes, we did not charge him with obstruction or anything like that. But the fact of the matter is this is someone who was in law enforcement for years and actually actively pursued evidence in a case against him to be released to the media because he believed that that video showed he and his son were not guilty of anything. That's 2 months afterwards. The state's position is he hasn't changed his mind. The state's position is he and his son still believe they didn't do anything wrong. And that is a lack of remorse or empathy. The idea that he did not intend the death of Ahmaud Arbery, once again, he's a law enforcement officer, got a gun, went running after somebody. The jury did find that he intended to commit false imprisonment, criminal attempt at false imprisonment, aggravated assault with that pickup truck, and aggravated assault with that shotgun. And we all know that felony murder has a foreseeability component to it. Ahmaud Arbery's death was foreseeable, and especially foreseeable to someone in law enforcement. The idea that they wanted to get to the bottom of what an unknown person was doing in some neighbor's house, a neighbor they didn't even know, goes back to our vigilantism. This whole idea that they were trying to help the neighborhood out has been an excuse from both Travis and Greg McMichael. Ms. Hogue got up here and said, this wasn't advancing the progression of the crime. And I apologize for this once again, Your Honor, but stop or I'll blow your fucking head off. I think that really advances the progression of the crime. You're threatening to murder somebody. You're threatening to kill him if he does not stop. And referring back to the post records produced in the bond hearing, Greg McMichael was so not paying attention to his job as a law enforcement officer that he was not post-certified from January of 2006 through 2014. He was an investigator in the district attorney's office, and he let his post-certification lapse from 2006 to 2014, 8 years. I won't even go into what that could have meant to those cases that were prosecuted by the district attorney's office. He then lost the post-certification again in 2018. And Jackie Johnson had to make an accommodation and change his designation at his job just so he could keep his job through retirement. This attitude of I'm special and I'm above the law and the law doesn't apply to me and I can take my gun and I can run after people and confront the homeless guy under the bridge and then call the police later about it. That's vigilantism, and that is the main reason. The thoughtlessness, the remorselessness, the desire so to be special and protect himself and his family by taking evidence and releasing it publicly when he knows there's an ongoing investigation is the reason we are asking for life without the possibility of parole. And with regard then to Travis McMichael. There's a reason, Your Honor, you did not grant bond to Travis and Greg McMichael. Mr. Rubin went back to all of those things listed in the bond hearing. The state will also direct the court to things the state presented in the bond hearing, including his text messages with all of his offensive racial animus and language. The jury did find that he had an abandoned and malignant heart. That's exactly what the jury found. They were given that he intentionally went ahead and did this, or the other level, abandoned and malignant heart. In addition, I will remind the court that there's an old saying, the road to hell is paved with good intentions. And it's great that they had such good intentions to protect the neighborhood. But the thoughtlessness, the lack of vision to know how this could go terribly, terribly wrong. And the fact of the matter is, Your Honor, it was a year and a half. February 23rd, 2020. November 2021. Travis came in here and testified. The state asks that you take into consideration his demeanor, his attitude. He said, this was the worst day of my life. Well, how'd that work out for Ahmaud Arbery? Not once did he show any empathy or ability to place himself in the position of Mr. Arbery on the stand. And yes, 4 minutes of conduct. Well, 4 minutes of conduct. Usain Bolt won 8 gold medals. When he runs those races, they're less than 2 minutes long. But the reason he's able to do that, the reason he is able to win, is because of 20 years of training that leads him to those 2 minutes. Those 4 minutes are a reflection and a result of an entire lifetime of Travis McMichael and his attitude, his demeanor, what he believes he's entitled to go ahead and go do. The same applies to Greg McMichael. That 4 minutes of conduct wasn't just 4 minutes of conduct. It was a culmination of vigilantism. We get to go ahead and play law enforcement even though we're not, and that we're going to go out and confront people, and we're going to take our guns to go do it without any real understanding or consideration of the consequences. At this time, for Travis McMichael, these are the reasons that we are asking for life without the possibility of parole. Thank you, Your Honor.
All right. That being all argument and evidence presented, and I say that just to be clear on the record, there had been some discussion with counsel about evidence and the record. The court is going to leave the record open, as I understand it, for what's going to amount to a notice of filing and 2 affidavits, just in order to preserve arguments made during the trial on appeal. I'm going to take about 10 minutes, maybe 15 minutes, and go through my notes, and then the court will pronounce sentence. We are in recess for 15 minutes.
All right, a very short recess, and the sentences will then be announced by the judge. I want to go to our expert panel because this was dramatic at the end, very dramatic, especially with Travis McMichael. Joey Jackson, the prosecutor just brought in what was not brought in to the criminal trial, text messages by Travis McMichael. She didn't specifically say what they were, but saying that they were offensive and obviously racially biased.
Yeah, I think that's very significant. And remember, that's something that you can open the door to, right? If you open the door to it by speaking about your client and his life and his family, et cetera, then I think certainly the court's aware of this already, because remember what the court does, Gene. The court is aware of all the issues. It's the court making decisions on what the jury gets to see, gets to evaluate, gets to determine by virtue of guilt. But with respect to making things fair and reminding reminding the judge, if the judge needs to be reminded when certain arguments are being made, then it's fair for counsel, right, in any rebuttal to do so. I thought it was particularly just very effective with respect to the snapshot in time. I think one of the things that carried the day hugely for me is the Usain Bolt example, right? Look, this is a person who did something in under 2 minutes. He's earned all these gold medals. Why? Because it's a lifetime of training, equating that with you are and you do what you are, and it makes who you are, makes you do what you do very effective. And one quick thing, Gene, before we move again to the other very distinguished members of the panel, is, you know, when you look and examine the issue of the attorney for Roddy Bryan, wow, what his arguments have been powerful in opening statement, which he waived. He distinguished his client from everybody else by saying, hey, he didn't know they had guns. Why not tell that to the jury, right? This is old news now, at the beginning of the trial. Why not distinguish your client and his behavior at the very beginning? You're making these arguments now at sentencing? Are you kidding me? And so I think at the end of the day, the judge has a lot to evaluate and consider. I think judges in large measure believe and know what they're going to do, but they want to reevaluate and assess what they're doing is the right thing. He'll check his notes, and the moment of truth, Gene, is very closely at hand.
Such great points, Joey Jackson. In addition, Kevin Goff constantly said, we're going to need to sever from this trial. We're going to sever from this trial. There were threats. He never did it. But if they had had a separate trial for Roddy Bryan, would it be a different
All right, the way the court's going to address this, I'm going to make a few remarks and then address each one of the defendants with regard to sentencing. And the remarks are intended to be general, but also taken into consideration in the individual sentencing portion of the court's statement. So that's how we intend to proceed. So the court has heard the evidence in the case, has accepted the jury's verdict, listened to the presentations here today in aggravation and mitigation, and candidly have spent a lot of time thinking about this. This is a case that has taken a lot of time and energy on a lot of people's parts, and has been a case of note, not just in this community, but really in a lot of communities. But what we're here today to determine is what an appropriate sentence is, quite separate from the notoriety of the case and any other outside influence that may exist. And so the court is going to be very careful in explaining that the court has considered just the evidence and what is appropriate under the circumstances of this case to consider in the Superior Court. So that all being said, let me start with this statement. As we all now know, based upon the verdict that was rendered in this court in November, Ahmaud Arbery was murdered. It's a tragedy. It's a tragedy on many, many levels. On February 23rd of 2020, almost 2 years ago, a resident of Glynn County, a graduate of Brunswick High, a son, a brother, a young man with dreams, was gunned down in this community. As we understand it, he left his home apparently to go for a run, and he ended up running for his life. He entered the English home at approximately 1:04 p.m. and left that home at about 1:08 on that day. At 1:14, Greg McMichael calls 911 to let them know that there's a black male running down the street. And within moments, Ahmaud Arbery is shot and killed. The three men that are now before this court chased him in a residential neighborhood for at least 5 minutes in pickup trucks, armed with a shotgun and a .357 revolver. The state mentioned this today about the time period, but I do want to put that time period in context. And the only way I could think to do so may be a little theatrical, but I think it's appropriate. I want us all to get a concept of time. And so what I'm going to do is I'm going to sit silently for 1 minute. And that 1 minute represents a fraction of the time that Ahmaud Arbery was running in Satilla Shores. That's approximately a minute. Again, the chase that occurred in Satilla Shores occurred over about a 5-minute period. And when I thought about this, I thought from a lot of different angles, and I kept coming back to the terror that must have been in the mind of the young man running through Satilla Shores. The jury heard the evidence and returned a verdict. And what a difficult job they had under the circumstances. Without any comment on the verdict itself, I think all counsel will agree and accept that this was a very difficult case to even get a jury impaneled on. And there are issues out there with regard to the jury that were brought up in the press and elsewhere. But I want to give credit to those members of the panel, not because of their verdict, just because of the fact that they were willing to go through the process that they went through with the state, with the defense, and with this court. We're here today to sentence the defendants. In discharging the duty, this court is required to consider all mitigating and aggravating circumstances. The court has considered those circumstances, including but not limited to all aspects of the crimes charged, the past criminal record or lack thereof of the defendants. I've also considered any lawful evidence which tends to show the motive of the defendants, their lack of remorse, their general moral character, and any predisposition to commit other crimes. Now, I think in this case, the record speaks for itself, and the defendant's own words, I think, guide this court with regard to sentencing. Went back through my notes and other resources to pull some of the quotes that we have in this case. I'll start with Greg McMichael. In my opinion, Greg McMichael, very early on in this, tried to establish a narrative. He made comments like, Ahmaud Arbery was trapped like a rat. Stop or I'll blow your, and I won't repeat it again, head off. He effectively admitted that he wasn't sure what Ahmaud Arbery had done wrong. Quote, I don't think the guy has actually stolen anything out there, or if he did, it was early in the process. But he keeps going back over and over again into this damn house. Again, back to the narrative. Told Travis, you have no choice. Told another individual at the scene, this guy ain't no shuffler. This guy's an asshole. Commented that he wanted him, Ahmaud Arbery, to know that we weren't playing. If I could have gotten a shot at the guy, I would have shot him. Travis McMichael claims he was in shock. But it's interesting because he talks about his concern for his child and his own well-being. Part of this was while the victim was actually laying there in the street. Commented, this is the worst day of my life. Well, I think it's been touched on here today. There were other individuals that were impacted. I look at the video of this incident. When I say the video, I think everybody knows what we're talking about, but there was one part of it that struck me as absolutely chilling, and that is, I believe it's in the enhanced video provided by the GBI. There's a frame where I believe Ahmaud Arbery, it looks to be, if he's 20 yards out, that may be close, 30 yards out. And it's the frame of Travis McMichael lifting the shotgun to fire at Ahmaud Arbery. And you watch that with context. And when I say context, after hearing the evidence in this case, again, thinking about a young man that had been running at that point for almost 5 minutes, and it is a chilling, truly disturbing scene. And we got there because Travis McMichael's father saw Ahmaud Arbery hauling down the street and calls out, let's go. At that point, Travis McMichael, despite whatever may have been going on in his life at that time, with regard to family or otherwise, just goes, grabs a shotgun and goes because he assumes that it is the right thing to do. Ahmaud Arbery was then hunted down and shot. And he was killed because individuals here in this courtroom took the law into their own hands. Mr. Bryan, he joined in after calling out to the McMichaels. Y'all got him? Claimed he didn't know what was going on, but obviously wanted to know if this individual who was running through the neighborhood, who he didn't know, had been caught in some way. Said, quote, I figured he'd done something wrong, but I didn't know for sure. All right, that wasn't actually Those quotes are two separate quotes. Didn't know for sure. I thought he would get away. And this is the part that is disturbing to me with Roddy Bryan. If the guy would have stopped, this would have never happened. All of these quotes give context, I think, to the video that we saw during the case. And Miss Wanda Cooper-Jones this morning made a statement that I think, when you look at these statements and you see the videos, is very true. And that is, she said, when they could not scare or intimidate him, they killed him. There's been discussion about remorse. And I agree with counsel that it is dangerous for defendants who have multiple prosecutions against them to make statements of remorse. But remorse isn't something that is simply a statement of regret. Remorse, I think, can be determined by looking at somebody's reaction to difficult circumstances and the reality of the situation that they're in. Again, it doesn't require an apology, and quite honestly, sometimes apologies are made simply to get past problems. Remorse is something that's felt and demonstrated. In this case, getting back to the video, again, after Ahmaud Arbery fell, the McMichaels turned their backs. It's, again, a disturbing image, and they walked away. This was a killing. It was callous, and it occurred, as far as the court is concerned, based upon the evidence, because confrontation was being sought. I think the statement was made during closing arguments. It's interesting to note that the most violent crime in Satilla Shores was the murder of Ahmaud Arbery. So sentencing does not generally provide closure. I think Ms. Wanda Cooper-Jones also talked about closure, but I don't find that it really does, and I think that's an unfortunate thing. Because in this case, I think many people are seeking closure. The mother, the father, the community, and maybe even parts of the nation. But closure is hard to define and is a granular concept. It's seen differently by all depending on their perspective and the prism of your lives. Instead of closure, maybe we'd best see today's proceeding as an exercise in accountability. We are all accountable for our own actions. Sometimes, in today's day and age, that statement is lost upon many. And today, the defendants are being held accountable for their actions here in Superior Court. Today demonstrates that everybody is accountable to the rule of law. Taking the law into your own hands is a dangerous endeavor. I'm not sure how this comes across. I'll say it anyway. I think ultimately, with regard to the murder of Ahmaud Arbery, it holds us all accountable. I read somewhere, and I don't remember where it was, that at a minimum, Ahmaud Arbery's death should force us to consider expanding our definition of what a neighbor may be and how we treat them. I argue that maybe a neighbor is more than the people who just own property around your house. I also believe that in assuming the worst in others, we show our worst character. Assuming the best in others is always the best course of action. And maybe those are the grand lessons from this case. I will let others spend as much time as they want writing about it and talking about it. But those are my general thoughts with regard to this case and sentencing. That said, with regard to the sentence in this case, as to Travis McMichael, Mr. McMichael, the court sentences you as follows. Count 1, malice murder, life without the possibility of parole. Count 2, felony murder, is vacated by operation of law. Count 3, felony murder, vacated by operation of law. Count 4, felony murder, vacated by operation of law. Count 5, felony murder, vacated by operation of law. Count 6, aggravated assault, merges into count 1. Count 7, aggravated assault. The Court sentences the defendant to 20 years consecutive to count 1. Count 8, false imprisonment, merges into count 1. Count 9, attempted false imprisonment, 5 years concurrent to count 7. That is life plus 20. Greg McMichael, the court sentences you as follows. Count 1, malice murder, defendant was found not guilty. Count 2, felony murder, life without the possibility of parole. Count 3, felony murder, vacated. When I say vacated, it's vacated by operation of law in all cases. I'm not going to repeat it. Count 4, vacated. Count 5, vacated. Count 6 merges into count 2. Count 7, aggravated assault, 20 years consecutive to count 2. Count 8, 10 years concurrent to count 7. Count 9, 5 years concurrent to count 7. That is life plus 20 years. Roddy Bryan, I do want to separate a little bit because the state is making a different recommendation. And despite the back and forth that Mr. Goff and I had during this case, I do want to point out a couple things that he raised that I think are appropriate to raise with regard to the sentence. As far as the remorse, I think Roddy Bryan stands in very different shoes. It is obvious from the beginning that he questioned the tragedy that had occurred at the scene and was on, I believe, I can't remember whose body cam, but the body cam, in fact, questioning whether or not what had occurred, and then took steps early on in this process, I think, that demonstrated that he had grave concerns that what had occurred should not have occurred. And I think that does make Mr. Bryan's situation a little bit different. However, Mr. Bryan has been convicted of felony murder. And I do not believe it can be disputed based on the facts of this case that the verdict was an appropriate verdict based upon the evidence presented, at least. And when I say appropriate, what I mean is legal. Because I believe there's been some discussion about some differences between Mr. Bryan and the McMichaels. There may be some differences, but it does not change the fact that was it not for the fact that Mr. Bryan used his vehicle in a way to impede Mr. Arbery's course of travel, this may not have ever occurred, and that is sufficient for felony murder. He did cooperate with law enforcement. I will point out Mr. Goff, 1710(1)B. There's actually a case out of Chatham County that says it would not apply under the circumstances of this case. So the court recognizing that Mr. Bryan's position is different. Again, Mr. Bryan was found not guilty on count 1 and count 2. The court sentences Mr. Bryan to life with the possibility of parole on count 3. Count 4 is vacated. Count 5 is vacated. Count 6, the defendant was found not guilty. Count 7 merges into count 3. The defendant is sentenced to 10 years consecutive to count 3 on count 8 and 5 years concurrent with count 8. Both of those counts, though, will be suspended sentences, which gives Mr. Bryan a life with the possibility of parole sentence. Those are the sentences, the court having pronounced sentence, first with regard to Travis McMichael. Mr. McMichael, you are hereby notified that under the law of Georgia, you are entitled to appeal the guilty verdict of the jury, and if you decide to do so, you must file your appeal within 30 days of this date. You are also informed that you have the right to retain a lawyer of your own choice to represent you on your post-trial motions and appeals to the appropriate appellate court of Georgia. If you cannot afford a lawyer, the court will appoint one for you. You are entitled to and will be given a transcript of all pretrial, trial, and post-trial matters without cost to you if you cannot afford a transcript. You may file a motion for a new trial, or you may appeal your case directly to the appropriate appellate court of Georgia for review. You are also advised that the statute of limitations for habeas corpus in this state is 4 years in the case of felonies and 1 year in the case of misdemeanors. The statute begins to run from the date the conviction becomes final. And just to be clear on the record, I'm going to go through the statement with regard to each defendant. So as to Gregory McMichael, You are hereby notified that under the law of Georgia, you are entitled to appeal the guilty verdict of the jury, and if you decide to do so, you must file your appeal within 30 days of this date. You are also informed that you have the right to retain a lawyer of your own choice to represent you on your post-trial motions and appeals to the appropriate appellate court of Georgia. If you cannot afford a lawyer, the court will appoint one for you. You are entitled to and will be given a transcript of all pretrial, trial, and post-trial matters without cost to you if you cannot afford a transcript. You may file a motion for a new trial, or you may appeal your case directly to the appropriate appellate court of Georgia. You are also advised that the statute of limitations for habeas corpus in this state is 4 years in the case of felonies and 1 year in the case of misdemeanors. The statute begins to run from the date the conviction becomes final. And then finally, Mr. Bryan, you are hereby notified that under the law of Georgia, you are entitled to appeal the guilty verdict of the jury, and if you decide to do so, you must file your appeal within 30 days of this date. You are also informed that you have the right to retain a lawyer of your own choice to represent you on your post-trial motions and appeals to the appropriate appellate court of Georgia. If you cannot afford a lawyer, the court will appoint one for you. You are entitled to and will be given a transcript of all pretrial, trial, and post-trial matters without cost to you if you cannot afford a transcript. You may file a motion for a new trial, or you may appeal your case directly to the appropriate appellate court of Georgia for review. You are also advised that the statute of limitations for habeas corpus in this state is 4 years in the case of felonies and 1 year in the case of misdemeanors. The statute begins to run from the date the conviction becomes final. I don't have a blue or black pen. Is there a blue or black pen down there? Thank you. The court has executed the statement of appeal for Travis McMichael, Greg McMichael, and William R. Bryan. If I could please have counsel and the defendants execute the statements of appeal to confirm they've been given, or the notice has been given. Anything further from the state?
Yes, Your Honor. The state would ask for a condition imposed along with this sentence, and that is this, that the defendants are not allowed to make any money off of their actions, such as a book deal, a movie deal, social media deal, or anything along any way, shape, or form, make any money off of this experience, this conviction, and this trial. And that should any money be made, that it go into a fund for the Arbery family. And I've had this condition imposed before, and given the nature of this case, we just seek to make sure that, based on their actions, having been found guilty of murder, that they do not then reap some sort of profit or benefit off of their actions via such remuneration to or from anyone in the form of, like I said, book deals, movie deals, consulting fees, or telling their story to someone in exchange for money.
There was a statute on this, but maybe I'm wrong.
It's not a SAM statute in other states. I'm not aware of Georgia's. If there is, I assume
Yeah.
Cite it.
Well, yeah, let's do this. Submit something more formal to the court. I'll go ahead and take a look at it.
Thank you, Your Honor.
And Judge, well, when the court does that, my only concern is how that would impact Mr. Bryan's ability to raise money for his defense, for his appeal. I wouldn't want to be in a situation where he couldn't do that inadvertently because of a sentencing condition.
Yeah, no, I understand the request, but I don't want to just offhandedly grant the request without understanding exactly what the terms are that the court is seeking. So I'd like something in writing from the state explaining what exactly the terms are that the state would be seeking with regard to the condition. And then I guess address that once that's come in more formally with defense counsel.
Thank you, Your Honor.
Anything from Travis McMichael?
No, Your Honor.
From Greg McMichael?
No, Your Honor.
From Mr. Bryan?
No, Your Honor.
All right, we are adjourned. Thank you.
All right, and there you see Kevin Goff shaking hands with his client,